Item number 1. Here in this matter, last Honorable Court's order on 25/6/2024, Lordship, Estate Officer was asked to, Lordship,
The order dated 24th of sir, 2020.
initiate, Lordship.
And it was a plot of land allotted to the one of the persons, the respondent.
Yes.
And they were declared for it. So that they had compromised the thing that was interfered by this order. And then they were asked to do a re-verification of the whole thing.
Yes.
And that last paragraph 19. Sorry. Paragraph. Because the compromise was not made by the governor. It was made by somebody else. State. Had determined the exercise in the paid para 11. Para 11 and 20. And they were supposed to submit a status report. So on the last date, considering the matter,
Yes.
Lordship, order is already here. Lordship, ADC was asked to initiate initiate proceeding, Lordship.
Yes.
But then, Lordship, they haven't provided any reports or, Lordship. I called them up personally, but then the estate officer, he has got into an accident and he has been hospitalized from last 1 month at the Guwahati, Lordship.
nobody facing him.
One in charge has been recently given, Lordship. I don't know if the in charge will be able to initiate action, Lordship.
So no status report.
No report, Lordship. So if your Lordship can allow us some time, maybe, Lordship.
And then the petitioner also probably pray for filing additional affidavit earlier.
Additional or affidavit pertaining to the challenging about the appointment or allotment to the private respondent. In this respect, I will be also filed. Yet to file.
How long is it there? How much time?
So another 3 weeks. Another 3 weeks, Lordship. At least.
Just this matter has been pending so long,
You are for the private respondent.
Yes, otherwise the prayers, which the petitioner has made, that's very simple for the state officer to be taken up, Last order, this honorable court has definitely passed an order that the state officers should, And affidavit, that has been pending for so almost a year now, more than a year. Because we also feel that Democrat's sword is hanging for almost 5 years,
So the state officer is not yet joined, or what did you say? The state officer is
Met with the
The estate officer is in hospital, Lordship.
okay.
And then some in charge has been, Lordship, given recently, Lordship.
Okay.
Someone has been made in charge, Lordship.
Miss Gothar
It will be very much.
at the line of government advocate, Arunachal Pradesh. Submits that the officer concerns, the state officer is hospitalized, due to which the status report could not be produced today and prays for some more time. The prayer is allowed. Mr. Tapo is Tapo.
5,
You are
4,
for-
5 and 6.
Oh, you are for petition.
Simudi.
I am focused.
Okay.
See more.
Mr.
Tapo.
Modi, land counsel for the petitioner is present. Mr. Tapo, land counsel for the respondent number
5 and 6.
5 and 6 is also present. A is prayed for, list this matter after 3 weeks.
3 weeks also.
Okay,
All right. Status report be produced.
on which date? After 3 weeks, date to be fixed by the registry. On which date? The land government advocate shall
Produce.
produce the status report,
Yes, that's
as directed. A is order on 24/5/2024. Okay.
much obliged.
Wait, please, lordships. Wait.
Yes,
Paper book is ready, man, it will be fixed for here.
okay. So can we fix for hearing?
Man,
Yes. Okay. You have received the
yes,
copy
yes.
and the state also?
Yes, your lordship. We have also received the copy.
इसके साथ दोनों उसको चलाइए इसके साथ
Mr. Dicky Pangalan, counsel for the appellant, is present. Mr. Ete, additional PEP is also present. So paper book is ready and the party has been furnished with the copy of the paper book. List is matter after
3 weeks, your
3
lordship.
weeks for hearing. Okay.
Deeply obliged, your lordship.
My lord, as for the earlier order, status report with regard to the progress of the construction of the road.
And they said that we are doing the work. Because they say only black topping is left, 45 years. And here 5 years. So now it's very much. The status report has been, it shows that it's progressing. It's the council and so on. So if it comes from somebody you can tell. And there is one more thing, sir. If you can come to the.
So
R15 is the subcontractor. Can take, you'll have to take fresh steps.
yes.
My lord, what I pray, since the it's a monsoon season now.
Hmm.
Will, can we allow the department some more time, my lord? Because as per instruction, now they are not doing the work because of the monsoon season.
Okay.
So just.
Your Lordship.
The TRB is subcontractor terminated. Terminated giving them paying me. Corresponding to 50 TRB in process. Can just ask me what is this subcontractor? If it's terminated, the work is being done by them only. They are already done.
That's number 15.
15, they say terminated. Page number 1, page number 1.
And my lord, further, my lord, because of the SIC case and all, NEC also have stopped the funding. They are yet to release 2004 lakhs, my lord, out of the total sanction fund, my lord. So these are also the hurdles what presently the department is facing. Because of the SIC case, NEC also have stopped the funding. So in any case, that they will have to pursue now for release of the balance.
That subcontractor has been terminated. Please tell me that we don't want it.
So, what about this respondent number
15.
15, subcontractor?
We have
Says
already,
that has been-
we have already served the notice, but they haven't represented by anyone.
Hmm?
They haven't represented by anyone. We have served twice.
By the
Yes.
Subcontractor, it says terminated as per the report. Subsequently engaged, sublet the work in submission. This subcontractor terminated.
BRB
But the report
infrastructure
has been
is
terminated.
no, my lord. Engage.
Your Lordship, I
Subsequently supplet to DRB
Where this
infrastructure.
word
The respondent number 15.
terminated is this?
My lord,
Terminated, subcontractor bracketed terminated.
terminated, yes, my lord.
Page 1.
Oh, yes, my lord.
She says they have served for Dusty.
Yes.
That is what is being done for it. Where is that Dusty? No, affidavit, Dusty affidavit.
Have you filed?
we have filed through the, not through Dusty, we have filed through this code.
Register.
Yes. Record might be there in the file, Your Lordship.
Unserved notice is returned.
Yes, we have served twice.
Unserved notice in respect of respondent number 15 is returned back to this
So
register.
we may file, we may serve again.
Huh?
If Your Lordship may permit, then we will serve again.
Press step.
Yes. Your Lordship, I may like to submit the prayer number D in the page number 48.
It is for appointment of independent monitoring committee or authority to oversee the progress of investigation and the road construction. Since it's been long, so people are suffering and no one is there to look after properly, because the SIC is looking after the case, but it is the state investigating agency, and the people who have done the embezzlement, they are from the higher authorities. So we are a little bit doubtful about that. So if there will be monitoring committee, then it will be very appreciative for the investigating process.
Okay. Is directed. The pursuant to the order dated 6/5/2024. The Learned Additional Advocate General Mr. N. Ratan has produced a status report of Sepa Changtajo Road within bracket 81.0 kilometer, which shows that some progress has been taking place in the construction of the road. However, due to monsoon, what do you say? What
Yes,
is
yes.
the mate?
Monsoon season, present monsoon season.
So now it is stopped.
Yes,
The work could not be progressed due to the monsoon season. The work could not be progressed for the time at the moment. And prays for some more time to complete the work. Start. Okay. In view of the above, some more time is granted to the respondent to complete the work in connection with relating to the construction of road 81 kilometer from Sepa to Changdajo. Stop. The Learned Council for the petition submits a petition appraised for some more time to take fresh steps upon the respondent number 15. Step be taken within 3 days from today by a registered post with AD. List is never. Okay, after.
well, since monsoon is likely to continue for quite a long time, my lord. After
September.
Okay,
8 weeks.
after
September, my lord.
September, after 8 weeks.
8 weeks.
Yes, my lord.
Okay.
After 8 weeks.
Status report they also produced.
Okay. Will be a date to be fixed by the registrar on which date the
State council.
state council shall produce the updated status report. Okay.
Obliged.
Meet these or in this matter, my lord, we are challenging the selection of Yachali as the district headquarters for the newly created KEPNR district. We had proposed and the place called Poblet, because there were certain difficulties with Yachali. My lord, I understand whether this may be a policy decision, but a policy decision cannot be taken arbitrarily. What I mean, if lordship agrees, if I may propose, my lord, if we have submitted a representation, if we are permitted to submit another representation and the authorities consider that, not, the matter may be closed, my lord, with a direction to consider our representation.
To consider the representation.
One representation, my lord, is from page 21, a representation dated 5/6/2024. This, my lord, district headquarters was notified by an amendment notification dated 23rd of February 24 at page 75, my lord. by way of the Amendment Act, my lord. The reason being, my lord, Yachali is very near to the present district headquarters of Lower Subalcity, my lord, 10 kilometers only. However, there is a guideline earlier, my lord. If my lord comes to page, the next page, page 76 onwards, there is a guideline. The operative portion, my lord, will find at page 79. That it has to be at least, my lord, 36 kilometers, the difference between two administrative units. Para A, my lord, subpara A at page 79. This is a guideline, my lord, of 1983 about how administrative units are to be, my lord, selected. If my lord comes to page 79. Clause A, my lord.
Okay.
The upper belt ranging from international port is sparsely populated. The land is underproductive due to severe climatic condition, and the area lacks surface communication. Therefore, lead a hard life as daily necessities are scarce. Being close to the international border, the area remains too sensitive, and people look at the other sides for facilities of social and economic welfare. People living in such areas must have full confidence in the government in its discharge of administrative and development functions for their benefit, though the population is small compared to that of the lower and middle belts. Since those areas are sparsely populated and considering the peculiar circumstances therein, creation of administrative unit with population of not less than 500 in the circle is recommended as a special case. However, such a border administrative unit shall not be located too close to another administrative unit and should be at a distance of not less than 2-day journey on foot, that is 36 kilometers by foot track, and 50 kilometers is if connected by road from the nearest administrative unit, provided conditions herein are herein after mentioned fulfilled. Manoj, so that was in respect of a border area, but I may propose one. Yachali and Manoj Zero are very near, and Hapoli are very near. So what I may propose, Manoj, that our representations may be considered by the government. There need not be a decision on merit, Manoj.
In case of approaching, they will consider and dispose of it as per the policy. So they can just say Mr. Rathod.
Yes, yes, state.
Manoj, otherwise they cannot claim this is for the guidelines is for creation of administrative unit. The PIL is for district headquarter. And in any case, whether the petitioner, they represent, first of all, they represent the majority of the key Panchayat district, whether it is in the public interest. Secondly, my lord, whether they have a right, legally enforceable right to claim that this particular place should be the headquarter. Whether this honorable court can decide that this place or that place will be better. These are all policy decisions of the government, my lord.
Now their only prayer, limited prayer is that representation may be disposed of.
Yes, that can be.
We are not pressing for.
No,
Yeah,
not
that's
pressing
good.
on for a decision on merits, Manoj.
That can be referred.
And if required, we may be permitted to submit a fresh representation as well.
Can I just ask him one thing?
Yes, please.
Mr. Nair, do one thing.
Ma'am.
You're not, don't press this thing. You pray for a liberty to file a fresh representation. My lord will grant that.
Ma'am.
That will be better.
Ma'am.
Otherwise, if we have to even ask you for a representation disposal, we'll have to say why
Ma'am.
you have a right to
Ma'am.
that.
Ma'am.
We find no right.
Ma'am.
So my lord says that you withdraw it
Ma'am.
with the liberty to approach the authorities.
Yes,
and
ma'am.
So we will
And
provide
we'll
for
consider in its own merits.
on merits.
Yeah.
Let him withdraw. to be considered on its own merit.
Please.
Heard Mr. P.D. Nair, learned counsel for the petitioner. Also heard Mr. N. Ratan, learned additional advocate general appearing for the Arunachal Pradesh, appearing for the state respondents. Mr. Nair, after arguing the matter at some length, has submitted that given the issue arising in the present proceeding, he may be permitted to withdraw the present PIL with the liberty to approach the competent authority for redressal of the grievances as raised in the present petition. The said prayer is not objected to by Mr. Ratan. So, in view of the above, the present PIL stands dismissed on withdrawal. However, liberty is reserved to the petitioners to approach the competent authority for redressal of their grievances. Also, it is further provided that in the event of any such approach is made in terms of the liberty granted by this order by the petitioners, the competent authority shall consider the said grievances in accordance with law and strictly in accordance with law and the policy of the government in place. Always. Instead of this will be closed, my lord. My lord. Deeply obliged.
This application managed to the state. Now, what is the grievance here is some anomalous things. The honorable court, when passing the initial order, so what happened is the initial order at page 15. Yes. Failure on the part of the state responsibility within time frame that is court would entirely petition to approach their proposition for payment of other items. Now, we have approached the that means this will be, then they find a file. In the file, they say that this one is the final is 8%. Now, leaving us in that, itself by way of an IA, and addition can be made, clarification can be made, but an addition to that, other than the market rate. So, those are not, I don't think so. The respondent is not.
None appears for the respondent.
It's not sincere. My lord, in item number 5, my lord, I'm appearing for the respondent number 2, my lord. In item number 5, my lord, I think this item is item 5, my lord. The matter is being taken up by your lordship.
Yes.
My lord, I need 10 days time to file my affidavit in opposition against the IA, my lord, for continuation of delay, my lord. Only 10 days time. My lord. Otherwise, we were in the same side. Anyway, even the other party is not present on stage.
Petitioner is not.
Petitioner is not present.
Can have it next week. Next week.
No, no issue.
No one represents the petitioner on call. You have for respondent number?
2, sir.
I'm for respondent number 2, Food Corporation of India.
Okay, Mr.
BK Singh, my lord.
Land Council for the respondent number 2, prays for some more time to file objection. Okay. Mr. Tapin, National Government Advocate, is present on behalf of
Appellant.
okay.
Applicant here.
Respond. Okay. So, please pray. List this matter after
After a week.
2 weeks.
My lord, on 5th of August, my lord, if it is not inconvenient, my lord, to your lordship.
It's paid
5th of
for by
August.
the Land Council for the part. List this matter on 5th August. Okay.
Highly obliged, my lord.
Still an ongoing process.
My lord, your lordship is ever my lord. Recently, government got settled, my lord. It will take some more time. My good news is, my hearsay that cabinet they have given the approval, my lord. So after that, my lord, it will rotate through the AR department for publication, all other things. So for that, my lord, at least, can this matter be listed?
No.
In the next week, we can place that position back. We can take that position in the party, we take it. Right, close the matter. 2 months time.
2 months, my lord.
Okay.
The pace at which the government works is fascinating.
Mr.
5 years.
Deepak, counsel for the petitioner is present. Mr. Modi for,
Respondent number 5.
okay. Just a minute. Mr. R.S. Navam, Land Council and Land Additional Advocate General is present
1 to 4, my lord.
for respondent number 1 to 4.
1 to 4.
And then Mr. Modi and Mr. Modi, Land Council for the respondent number 5. Stop. After 2 months, after?
My lord,
2 months, my lord.
after 2 months,
My understanding
I
is
believe that till then
now-
it will be settled down, my lord.
by 2 months.
It's agreed upon by the Land Council for the party. This is matter after
2 months.
2 months. Okay. Then we'll do that one. Then Mr. R.S. Navam, Land Additional Advocate General submits that the matter is before the
Has been cleared by the cabinet.
matter has been
Finally.
cleared by the
My
cabinet.
lord, that's what my brother informed me, my lord.
That-
Actually, I
that-
don't have any instruction, my
The
lord.
final stage of consideration.
Okay. At the final stage of consideration and
That will be better, my lord.
2 months time is given. And it agreed upon by the Land Council for the party. This is matter after 2 months.
Deeply
It
aware.
to be fixed by the registry. Okay.
With my lord's kind permission, may I mention, my lord, item 16. Item 16 in today's board, my lord.
Yes.
Item 16, if your lordship sees your last order of 17 June, the other side was directed to file the affidavit. Till today, they have neither filed any affidavit nor they are appearing.
So what do we do?
My lord, they have to comply with the order of 14 March 2024, by which the direction was given by Justice Nair them to file an affidavit, the complainant. And since they are not filed and they are taking adjournment after adjournment, I thought to make a request. And yesterday I mentioned this matter, my lord. If you remember that I will be occupied in Supreme Court here after lunch. And so I thought I may take this liberty and request in your indulgence, I can seek.
Who appears for? The other side.
Your Lordship, I'm appearing for the state. The private respondent is not appearing. Or
Mr.
maybe
D.
they will
Verma.
appear.
Mr. D. Verma was supposed to appear, but he had not been appearing in last 3-4 hearing, even last hearing before your lordship on 17 June. He was not there. And compliance has to be filed by him.
So today also he is not appearing.
He is not there. It seems.
Your Lordship,
Not in a court.
we don't know, Your Lordship, whether
Okay.
because it's a mention
Now-
hour, Your Lordship.
What do you want now?
No, I'm drawing your lordship's attention to this because after lunch I may not be available. So I thought I can take this liberty. The lordship had to fix on some other day then.
Okay, when do you want?
Millard, can it be 13th of August, Millard?
Okay.
Then, Your Lordship, in that case, we have received the case diary, original case diary, that may be sent back. For
And
now.
interim order is to continue.
Okay, but the private respondent is not present today.
Yes, it's not,
in the court.
now he is not present
So
because
it
it's
is
in
absent.
mentioning hour, Your Lordship. This is the
Hmm?
mentioning hour. The matter is not reached in a usual course, Your Lordship.
Okay.
No, he had not been appearing in last 4 hearings.
Hmm. Now, today we do not know whether he is present or not. Somebody
I
may represent
appreciate-
him. He refers to him. So you want this matter to be fixed on 13 August?
Yes, my lord.
Okay.
Your lordship have to continue the interim order.
So the state has received the case diary? Case diary.
Case, the original
Not yet
case,
filed charge sheet.
not your lordship, because some this CDR and all has to be obtained from the concerned authority, which is yet to be obtained. And for that reason, charge sheet has not been filed yet. And
Okay.
there is an order from the court that no coercive action against the accused person. Only to that extent, not on investigation.
Yes,
Investigation has not been stayed, your lordship.
Okay.
So CD may be returned at this stage and again may be called for on the next
Okay.
day.
Lord, if Lordship permit, Lord,
It
with due
is
permission
grateful.
of my senior, Lord, I am assisting Mr. Lahoti in this case. I am appearing from Guwahati, my Lord. In fact,
Appearing for? You are appearing
in
for?
the same case, my Lord, I am assisting for the petitioner hearing. I am assisting Mr. Lahoti in this case, my Lord.
Okay.
Lord, only thing, Lord, I think your Lordship has extended the interim order until further order on last few occasions, Lord.
Okay. So as prayed for by the Land Senior Council, assisted by?
R.
Assisted by?
Dubey. R. Dubey, my Lord.
Okay. Land Council for the petitioner, list his matter
22nd.
on 13/8/2024. Stop.
I hope it's
I can request my senior. Lord, can it be, Lord, if subject to my senior approves, Lord, on 13th I will be in Calcutta, my Lord, if he
So
doesn't
it
have
can be
any
on
inconvenience.
22nd. It can be on 22nd then, my lord.
22nd.
22nd.
8.
Yes,
Okay.
I'm sorry.
Mr.
Interim
Ete,
order,
Land
interim
Additional
order.
PP is also present. So the prayer is prayer not objected, huh? Accordingly, the prayer is allowed. List is matter on 22/8/2024. Stop, huh? On which stage the Land Additional PP shall produce the updated CD. Okay.
And my lord may kindly consider
In
the
the
affidavit which
meantime,
your lordship are directed had not yet been filed.
in
Your
the
lordship
meantime,
directed.
the interim order pass RS will continue. Okay.
Case diary may be returned, your lordship. That may be
Yes.
reflected. Case diary returned.
So on that, you
Yes, I will produce the
updated
case diary.
Okay.
Oblige.
My lord, I was indicating that your lordship had directed them to file the affidavit by 17 June order. They have not yet filed any affidavit. Kindly that be recorded, my lord. Affidavit is directed by 17 June has not yet been filed.
In the meantime, the respondent shall file their affidavit as directed.
In the 17
On
June.
which date?
17 June it was directed.
As per the direction of this court on 17 June 2024. Okay.
Oblige, lordship.
Grateful, grateful.
Back to the lordship.
Yes.
Back to mention item number 30.
Yes.
Can this be taken up next Tuesday?
13 is with 12.
30. 30.
30.
Next Tuesday. I will inform the RS.
So who is for the other side? They are present.
Yes. Mr. Tapak, I have informed. Mr. Tabit Tapak, I will inform.
Okay. Mr. Dicky Pang, Land Council for the petitioner, with the consent of the Land Council for the other sides, prays for listing this matter
Next Tuesday.
next week. The prayer is allowed. List this matter next week.
Can it be on Tuesday? Next Tuesday.
Oh, Tuesday. Okay. Pray for list this matter on Tuesday is which date?
Tuesday.
23rd. Okay, the prayer is allowed. List this matter on 23rd accordingly. Okay.
May I, Your Lordship?
Yes.
And Your Lordship, I beg to mention item number 23, Your Lordship. We have received a paraphrase reply. We need some more time for filing our counter affidavit. 3 weeks
You are
time.
for?
I'm for this state, Your Lordship. 1 and 2.
Yes.
We need some more time, Your Lordship, for filing our counter affidavit.
Have you informed the petitioner?
Yes,
My
Your
lord,
Lordship.
let me pay
I've
them.
taken
Okay. Yeah, some more time to file.
counter affidavit.
Okay. Mr. Leasing Permit, line counsel for the petitioner is present. Miss, her name, huh? Line counsel for the state respondent, prays for further. Prayed for how much time?
3 weeks time, Your Lord.
Further 3 weeks time. To which the line counsel for the petitioner has no objection. Accordingly, the prayer is allowed. List is matter after 3 weeks.
My lord, may
kindly continue the interim order. Order is there. The interim order passed earlier, shall continue till then. Okay.
Lordship, I would like to mention item number 5. I'm from the petitioner's side. So Lordship may grant adjournment for today. Opposite counsel has been consented.
Okay, you are Miss
Tabayani,
line counsel for the appellant with the consent of the
Yes.
other side. Praise for listing this matter after.
next week.
Okay, matter next week. The prayer is allowed. List this matter next week accordingly. Okay.
Obliged.
May I please, my lord?
Yes,
My lord, I beg to mention item number 7, my lord.
item 7.
Yes, my lord. Here I am for the respondent and I take consent from the appellant, my lord.
Okay,
My lord, matter may be listed after 2 weeks, my lord.
Mr.
And Sora.
N. Sora, line counsel for the respondent number.
All
You
the
are-
private respondent,
Okay,
all the
for-
respondent.
So other respondents are also there.
No, my lord.
Okay. Respondent, huh? With the consent of the line counsel for the appellant. Praise for listing this matter after 2 weeks.
Yes, my lord.
The prayer is allowed. List this matter after 2 weeks. Okay,
My lord, I'm for the petitioner side.
here in this case,
Yeah. My lord, it's.
do you have any objections
Yes. Matter is very urgency, so it may be fixed after 1 week.
after 1 week?
Yes.
Okay,
1 week.
after 1 week. Then make it 1 week. Mr., you are Mr.
For the quarter Teresa,
Your good name,
Bingya Punu.
okay, appears on behalf of Mr. Koda Tarilana counsel for the appellant. Okay,
Deeply obliged.
May I please, Your Honor? Your Honor, I beg to mention item number 9. With the
Item
consent
9.
of the respondents, this matter may kindly be taken up tomorrow, Your Honor. This matter may be taken up tomorrow.
tomorrow.
Yes, Your Honor.
So what is this matter about?
My lordship has already heard the matter almost for 4 hours, but last,
Hardly argue.
Okay,
I don't know, tomorrow is Friday, my lord.
tomorrow.
Lordship,
The
the
petitioner's side of the
PPA,
arguments are completed and the respondents are yet to argue the matter.
the PPA case, my lord.
Hmm?
PPA case,
Yes,
yes.
tomorrow. Tomorrow, probably it will not be possible. Next. Thereafter,
Your Honor, next week, this honorable bench will not be sitting, so it has to be tomorrow or else it will take longer.
if you want to continue with, then I think we may have to
Your Honor,
adjourn.
because the senior counsel, he comes from Guwahati and he would like to be present when the respondents are arguing
Okay.
the matter. So he.
Then next
he's-
time,
I'm always ready, my lord.
okay. Mr. Tapulani counsel for the, no, Miss
T.Y. Bhutia.
UI Bhutia, Lana counsel for the petitioner. This is fixed matter. Okay. Praise for adjournment of the case for the day. Mr. Tapu, Lana counsel for the respondent. There's no objection. Stop. Case prayed for by the Lana counsel for the petitioner. List this matter is list this matter after 4 weeks.
Your Honor, tomorrow. Your Honor.
Tomorrow it will not be possible. Tomorrow is last date, and then thereafter tomorrow it will be difficult. It's a part hard matter if you want Hmm? As and when this, if
Because
you
then
want
this-
this to be listed as a part or matter, then as and when these
Yes,
bench
look at-
sheets,
read it.
or otherwise can release.
Then it may be fixed on Monday on.
Oh, नहीं होगा बोला ऐसे में
Monday, there will be a fresh hearing then.
That is the case, Your Honor. Then it will take a long time.
Hmm.
Because senior counsel, as I've been informed, he's already left from Guwahati. And as submitted by the respondents, he will not take more than half an hour. And our side of the argument is already completed.
So, what do we do?
Up to
My
the
humble
petitioner
request is
and
that
all
it
this.
may be
You want to
listed
keep
tomorrow.
this as a part or matter?
It
My
seems
prayer is that it may be listed tomorrow, as I've been instructed by Mr.
Tomorrow will be difficult because tomorrow, the matter for tomorrow already listed, and then that is all which I can take up for tomorrow, because day after tomorrow I'm leaving, and then after hearing, I'll not be there. Even if I hear
Yes.
also, it will be difficult. Tomorrow it will be
Then
difficult.
for now, Your Honor, maybe I may be given some time. I'll consult with them.
Hmm?
Then let the matter come up.
As a
Let the matter come up today, Your Honor. As
Today?
and when, according to the
Okay.
causes, till then I'll take the instructions.
Hmm.
Obliged.
My lord, item number 1 may be kindly pass over. The council is in another court engaged in
Kindly.
hearing.
Okay. Password for time being.
Yes, sir, for
Okay.
time being, yeah. Obliged.
May I please, my lord?
Yes.
My lord, this criminal petition is jointly filed by the accused, informant and the victim, as they have settled the matter mutually outside of the court. So, my lord, before submission of brief fact of the case, I read all the content of FIR. FIR is in page number 12, my lord.
This is a person petition.
Yes, my lord. Only section, my lord, initially section was 447 and 323, but after framing of charge, it was altered. Section 324 was inserted.
Which is not compatible.
Yes, which is not compatible.
So,
Unless matter has already settled, my lord.
where is the settlement agreement?
My lord, this is page number 64. Page number 64, 65, and 66.
Just a minute, sir.
Yes.
Where is FIR you said?
My lord, FIR is page number 12.
Just a minute. Huh?
May I read out, my lord?
Hmm.
With utmost
Okay.
trust.
Hmm. Yes.
With utmost respect, I, on behalf of the law-abiding citizen of Doimuk, would like to inform you that Mr. Tana Tagi, son of so-and-so, resident of UPA, Village 1, POPS Doimuk, Papumpare, Arunachal Pradesh, has physically assaulted my labor or worker, Mr. Ranjan Nath, son of so-and-so, address so-and-so, presently residing at UPA 1 Village so-and-so, at around 11 a.m. on 1st April 2019. On other hand, I entered a matter for compromise, but he refused. Rather, he brought a lethal weapon down, in addition of beating with bamboo stick, kicking and compel of boxing and slapping him. In addition to this incident, a member of same family sometime distract my personal property in my absence. This is the allegation, my lord. This,
Where is the agreement?
my lord, agreement is page number 64. This petitioner number 1 and 2, they are neighbors, my lord. And when while constructing a building, and English is petition number 3, who is the labor of petition number 2. Some that plywood was just blocked the road of the petition number 1. So there was some arguments, and consequently some pushing and pulling was there. So on that regard, this petition.
Have you annexed the order of the CJM or JMFC?
My lord, this matter is pending before CJM.
CJM.
Yes, sorry, my lord, JMFC.
JMFC. Have you annexed the order?
My lord,
Framing
order,
charge?
framing charge order is not annexed here, but my lord, section 320 was inserted. That insert section is not, that order is not annexed with charge sheet.
324. Yes, state.
Yes, Your Lordship. Lordship, the charge sheet has been filed in the year of 2019, Your Lordship. It's already been 4 years, Your Lordship. We'll need the record in that matter, Your Lordship, to ascertain the stage of the proceeding.
Okay. Mr. Rahman, Learned Counsel for the petitioner. I've also heard Ms. Tijini Lanet, additional EP, state of AP, stop, para. This is an application under section 482 of the Code of Criminal Procedure 1973, praying for quashing of the FIR dated 01/04/2019. No, where is the GR case? Have you mentioned?
My lord,
Where is the case number of the court?
my lord, I mentioned in cause title also.
Where?
Cause title first para, my lord.
First para is the FIR.
Is FIR number. FIR
Good.
dated 1/4/19, registered remove PS case number 13/19 under section 447.
No, that is only FIR only.
Yes,
You say that a case has already been charge sheeted and then
Yes, my lord.
charge framed.
yes, my
So
lord.
in which case charge framed?
Well,
Well,
under section 447 and 320,
no,
320.
that is there, but GR case.
GR case is not clearly mentioned in charge sheet, my lord, so
That's how.
I could not find out the
No,
GR number.
in the code. In the code, it was registered as what case? GR case.
GR case is supposed to in charge sheet, my lord, so
No, no.
GR case number is not fine.
In that case, Your Lordship may kindly take this matter after a while, Your Lordship. Let my friend ascertain the GR number and pending before which court, Your Lordship.
Because if the case has already been charge sheeted, then you see your prayer is for the quashing of FIR.
Yes, ma'am.
And without mentioning the case number, it will be difficult for you rather. After some time.
After some
Yes.
time, Your Lordship.
Okay. Otherwise, only the notice is to be issued. Order
Yes.
can be passed, and then later on, if you find a GR case,
Yes.
it's there.
Yes.
Okay.
Because otherwise, Your Lordship, the only issue here is that Your Lordship will be calling for the scan copy of the
Yes,
record.
that is why.
That is,
So calling for the case, scan copy of the case, the record, then we need a number. That is why.
after some time, otherwise,
Okay.
because the court is here itself,
Okay, okay.
Your Lordship.
Yes, ma'am. All right.
After some time. Huh?
With pleasure, Lordship. Item number 3, Lordship.
Yes.
Yes, Lordship. Lordship, this is regarding invocation of BNSS, Lordship, BNSS or CRPC. On the last occasion, I have provided one order.
Have you
of
gone
the-
through?
Yes, Lordship.
Have you gone through the saving clause?
Yes, Lordship.
Yes. Now, what is your submission?
Lordship, my submission is, Lordship, in this regard, Lordship, various courts, Lordship, having various point of
It's
view,
not
Lordship.
clear. It's not clear.
Made Lordship, made pleasure, Lordship. Lordship, regarding invocation of BNSS, Lordship, Lordship, various court have various opinion, Lordship. And the principal seat of Guwahati High Court also already passed an order, Lordship, on 11/7/2024, on an bail application, Lordship. I have provided the copy of the order also, Lordship. The Justice Eddie Chaudhary has passed an order, Lordship.
Habil Ahmad case.
Yes, Lordship. Yes.
Habil Ahmad versus State of Assam.
Yes, case number, bail application number 1978. Yes.
1978 of 2024. Yes, Your Lordship. That, Your Lordship,
Yes, yes.
it's already there. There, nothing, no law has been laid down, no interpretation has been made. It's simple an order wherein the party has been given an liberty to change the cost title. That's it, Your Lordship. No law has been interpreted, Your Lordship.
So I think in view of the saving clause, you may have to.
Your Lordship, this is the copy of the order of the Honorable Principal Bench High Court, where.
And then you see, the police, while registering the case, has not inserted this 75 of BNS. You have inserted by yourself.
Yes, that section is inserted by him
yes.
because that section is corresponding to the provision of BNS. And Your Lordship, it will not have a retrospective effect.
Yes.
The offense which has committed prior to the commencement implementation of the new code, the IPC will be there, and the police has registered the case under the old code, not under new code.
So, Lordship, my submission is, Lordship, regarding putting the provision of BNS, Lordship, on that part, Lordship, I may be allowed to correct the cost title, Lordship. And regarding BNSS, it is up to your Lordship, Lordship.
If Your Lordship, if my brother is pressing on the maintainable, if the application is maintainable on BNS, then Your Lordship may decide on maintainability, whether it will be maintainable under BNSS or under 438 of the CRPC, Your Lordship.
Yes.
So to support my submission, Your Lordship, I will rely the latest order, the recent order of the Rajasthan High Court judgment, Your Lordship, wherein, Your Lordship, the discussion has been made on the repeal clause as well, Your Lordship. The new code, Your Lord.
Yes.
So, Your Lordship, regarding the principal bench order, Your Lordship, there no doubt, no discussion, nothing has been made. But now here, Your Lordship, the recent judgment of the Rajasthan High Court in Krishnan Joshi, reported in 2024 Supreme Online Raj, page number 200, Your Lordship.
Yes.
Your Lordship, may kindly come to para 5. Here, Your Lordship, initially what has happened, the petitioner, they have filed the 482 application invoking 482 of the CRPC. However, the registry has rejected and has instructed the petitioner to file under 528 of the new code. And this issue was raised before the court, Your Lordship. So now, Your Lordship, it's in para 5. We are concerned here only with the saving clause contained in subsection 531 to a perusal thereof clearly reflect that not only the pending trial, appeal, but even an inquiry or investigation which is underway prior to coming into force of BNSS shall have to be dealt with according with the provision of CRPC 1973 and not under the BNSS 23. The reason for the same are not far too sick. What has to be seen simply is that of registration of the FIR and law as applicable as on that of which such registration. Treat it may sound, but settled position is that the moment an FIR is registered under section 154 of the CRPC, criminal investigation administrative machinery is set in motion under chapter 12 thereof. Thus, if an FIR is registered prior to 1/7/2023 under the CRPC, it would amount to pending inquiry investigation within the meaning of section 531 2A of BNSS. The entire subsequent investigation procedure, even the trial procedure qua, such an FIR shall there be governed by CRPC and not BNSS. 6.1. Let us analyze it deeper by dwelling further on it. Legislative process often involves simultaneous twin action, that is 4 of 8, not only the creation of new law, but also the repeal of existing one. At the same time, section 531 of the new legislation code, for short refer as BNSS, avenges the repeal of the Code of Criminal Procedure 1973, and it also incorporated crucial savings provision, which is so essential to further the transitional period between the old code and the new code. No doubt, section 531 of BNSS effectively remove old code from the statute books. However, at the same time, it is a repeal subject to the saving clause and not a repeal in toto. A certain transitional period has been provided, and rightly so, for a forthwith repeal in totality shall lead to a legal uncertainties, particularly concerning ongoing legal proceedings that commence under the old code. To mitigate such uncertainties, saving provision has been introduced. Saving clause ensures that the repeal of an old code does not adversely affect any legal proceedings or rights that were established under the old code. The saving provision facilitates a smooth transition from old legal framework to the new one. It provides a buffer period during which the judicial and legal system can adjust to the changes introduced by the new Sanhita. The saving clause in section 531 subsection 2, subclause 2 is critical for ensuring legal continuity and stability. It stipulated that notwithstanding the repeal, any appeal, application, trial, inquiry, or investigation pending before the new Sanhita come into force will continue to be governed by the old code of the Criminal Procedure 1973. This shall essentially mean that all ongoing proceedings which have already been kicked in under the old code will not be disrupted by new code, that is BNSS. This is vital for maintaining the integrity of the judicial process and ensuring 558 that justice is neither delayed nor denied due to procedural changes. Should an affected party feel so, right of the accused in an FIR and or under trial and or convict under appeal and the legal expectations formed under the old law have been and are required to be protected. Applicability of old code on pending matter prevent any retrospective adverse effect that might arise from the sudden application of new legal provisions to ongoing cases. Furthermore, while saving clause, the litigant already involved in legal proceedings initiated under the old code have been thus assured that their cases will be resolved under the legal framework they were initially engaged with saving. Saving clause thus ensure the repeal of old code does not create a legal vacuum, leaving ongoing proceeding in limbo, and to avoid such a scenario, the old legal process ought to be continued seamlessly. Speaking of judiciary, why the saving clause which avenges dual approach, that is ongoing case to be disposed of under the old law and one registered after 1/7/2023 under the new code, even the court can manage their workload for efficiently. Judges and lawyers familiar with the old code can continue their work without needing to adapt immediately to the new provision. Section 531 of the new Sanhita, while repealing of the Code of Criminal Procedure 1973, simultaneously does safeguard ongoing legal proceeding, though its saving clause 7. No doubt, procedural law can be applied retrospectively, subject, of course, to the judicial review. But in view of Section 531, subsection 2, clause A of BNSS herein, it is amply clear that all the pending matter prior to coming into force of BNSS 2023 as 6 of 8 is specifically mentioned in Section 531 2A of BNSS shall continue to be governed by old code, that is CRPC. Therefore, the petition in hand also has to be treated under 482.
Yes.
This was the settle, Your Lordship. And in addition to that, Your Lordship, here in this judgment, the Rajasthan High Court says on the date of registration, Your Lordship. But what my humble understanding would be, Your Lordship, it will be from the date of commission of the offense. Because, yes, Your Lordship, the court, we cannot ignore the provision of the limitation period which are governed under 468 of the CRPC, Your Lordship.
Yes, yes, this seems to be the correct approach.
Yes.
And then because it has to be from the date of commission of the offense.
Yes,
as in
exactly.
the case of the JJ Act also.
Yes, yes, Your Lordship.
If the offense was committed while he was still juvenile,
Yes, Your
then
Lordship.
it will governed by the JJ Act.
Yes, Your Lordship.
So in the same way, it should be from the commission of
Commission of the offense, Your Lordship.
because sometimes it happens that the offense has already been committed.
Yes.
But then FIR it takes time.
Yes,
to
it
close the
takes
file.
time, and it is governed under 468 of the CRPC. And in saving clause also, Your Lordship, in BNSS it has provided that the BNSS cannot be an enable provision for condoning such delay, Your Lordship, which has been committed and prior to the coming to force of the new code. So it will be from the date of commission of the offense.
So because not only this, but then other likely to file some applications in the same way.
Yes, Lordship.
We need to know. So this application is on 482, and also not only that, but he has also added 75 also.
Yes.
Section 75 of BNS. apart from the 482 of the BNSS.
482 is the corresponding section of all code,
Yes.
438, Your Lordship.
Yes, yes. So it has to be
Under 438.
438.
And section under which my brother has altered, that section 50 or 70 of BNSS, that is also required to be altered. Because it's under section 354 of IPC, Your Lordship.
So, Lordship, I may be allowed to correct the cost title in the meantime, Lordship.
Okay, so what we'll do is we'll pass an order
Yes, Your Lordship.
clarifying these, and
Yes.
then in the meantime you correct.
Yes, Your
thereafter.
Lordship. Okay, Your Lordship.
Mr.
N Rai, Lordship, N Rai.
N.
Rai, R-A-Y.
Right. Land Council for the accused applicant. This is AB.
AB, Lordship.
Okay. I've also heard Mr. Ete, Ete, Lanet additional PP, state of AP, huh? So provided he correct by inserting the amend the course title.
Yes.
And then this can be
Your Lordship, that specific observation may be
this
given.
observation will be-
Yes, so that
and
it
then
will be
thereafter-
helpful for the other
Right.
petitioners also, Your Lordship.
Right. The petitioner filed this application under section 482 of the Bharatiya Nagarik Suraksha Sanhita 2023 for granting of pre-arrest bail. Apprehending his arrest in connection with Namsai PS case number 71, 2023, under section 354A of Indian Penal Code 1860 and under section 75 of Bharatiya Nyaya Sanhita 2023. Stop. Para on perusal of record, it reveals that the FIR was filed on 2/12/2023. And registered on the same day as NMS Namsai PS case number 71, 23 under section 354A IPC. So this observation, what I'll do is a record we will call for, and then some observation are made.
Yes, Your Honor.
Pass an order.
Okay, Your Lordship.
Okay.
Okay.
So in the last, so this observation will be there. call for the charge sheet not yet filed.
Not filed, Lordship.
Your Lordship, this is in motion, is a the petitioner need to correct the cost title, Your Lordship.
No, that will be corrected. He will be corrected.
Okay, Your Lordship. Then in that case, Your Lordship, CD has to be called for. This is motion stage.
Yes, because after that observation.
Yes, Your Lordship.
He is allowed to correct.
Yes.
Hmm.
Okay.
So, call for the case side.
Yes.
Case side.
Yes.
This is matter on next week.
Yes, Your
I'm
Lordship.
sorry.
Yes,
Scan
Lordship.
copy of the case study, huh?
Yes, Your Lordship.
This is matter on
25th, Your Lordship.
25th.
Yes. Sir.
Okay. Is there any? Okay. We'll pass
Hello.
on.
Yes, Your Lordship. My Your Lordship, the only submission would be, it will be from the date of commission of offense.
Yes.
Date of commission
It
of
will be
offense.
date of from the date of commission of offense.
Offense, not
Because
registration, commission of offense.
registration can be done only after
After
seven
the
also.
coming into force of this Sanhita also.
Yes.
But from, it will be computed from the, considered from the date of commission of offense.
Date of commission of offense.
Yes, Your Lordship. Yes, deeply obliged.
Yes.
May I appellate, Your Lordship? Well, in this matter, we are challenging the impugn order passed by Deputy Commissioner and confirm that the Gram Panchayat who were elected, I will just take to that in actuals, Gram Panchayats who were elected from the Congress party, but then later they resigned and then they were also expelled.
What is wrong in the impugn order?
Yes, impugn order, my lord, we are just basing on the section 3, section 1A subclause 2 of Arunachal Pradesh Local Authorities Prohibition of Defection Act 2023, where it says that if it has to be merged, they have to be active member and he should be in the political party, original political party. Once you resign from the political party, they are no more member. They are no more member, they cannot merge. Merging is no question. So in this our case, they were elected from the INC, they resigned. And then even the High Power Committee, they have initiated
this. It's a case of merge.
Yes.
Okay.
They have initiated disciplinary proceeding. They were expelled. And then what they have done is that
shown it as a merge.
They are shown as a merge. And then they move the no confidence motion against the petitioner, who is a chairperson.
Let us see the provision first.
Yes. So the provision is very clear about that. I may just refer this one, Arunachal Pradesh Panchayat Raj Manual 2018 Panchayat Raj. If the book is available, we will refer that. Latest is March 2020. This is the book. So this is the correct. You can refer correct page. So I may just take to page 164.
Yes.
Yes, 164 is this is the state legislation is called Arunachal Pradesh Local Authorities Prohibition of Defection Act 2003. And then important section is page 165. Is section 3, 3 is about disqualification on the ground of defect. So may I read the
Yes,
section 3 clause 1. Subject to the provision section 4, 5, and 6, a member belonging to any political party shall be disqualified for being such member. A, if he has voluntarily given up his membership of such political party. This is our case. And second, and 3 is clause 2. May I read that also? A
Yes,
person.
sir. If he has voluntarily given up his members. Yes.
Political party. Means they resign. They resign. And 2, may I read that 2 also? A person elected as a member has a claim that he or any other members of his political party, a person elected as a member of otherwise then as a candidate set up by a political party shall be disqualified for being a member if he joins any political party after the election. But in our case is 3(1)(a).
Otherwise, the political party. Yes.
Now, your lordship has to see is that once he has voluntarily given up his membership of such political party, especially in our case is the Congress party, can he merge to other party and move the no confidence motion? This is our case. So now I will just come to the annexures when they have resigned and when they have merged and when they have issued the minutes of meetings and when they have shown as a merge by the defected political parties. So may I just take to first page 28. Merge can, your lordship, merge can possible. Only thing is that they have to be active political. They have to be active member
of that
that original political party. They can merge into other party. They can resign, and they can, if they want to move no confidence motion, that's no issue. But in our case is that they are no more member of that particular original political parties.
Whether they have used the word merge.
Yes.
Whether have they used the word margin?
Yes,
Merge?
they have.
Where?
It is in the order. It's in the impugn order. I will just check.
Let us see the impugn order first.
Yes. Page 55. 55. 55. Yes, may I read page 55?
Page 55.
Yes, annexure 14.
No, this is forwarding to.
This was
Deputy Commissioner.
Yes, this was
by the member secretary.
This was forwarded by the member secretary because if any proceeding of a Gram Panchayat, it has to go through the member secretary. So the minutes of meeting was placed before the member secretary, and then member secretary recorded the minutes of meeting, and he placed before the deputy commissioner for necessary actions. So may I read just that one?
Yes.
Page yes. Okay. May I also read before that? May I just read page 31?
What is that?
This also talks about the merging, how they have merged. Page 31, annexure 7.
Yes.
Yes, may I read? May I read this whole paragraph?
It's the same date.
Yes, yeah, almost same.
It's not a. I think this is the same letter.
Same letter.
Same letter.
No,
Date, same, everything same.
This the 55 one is forwarded by the member secretary.
Okay, then and what is the 31 is also?
31 also is almost similar writing to the deputy commissioner but a different
The
date.
same letter.
This was on 7th
This is
May.
same letter.
Yes, same 7th May. And another is of
7 May.
14
The same letter.
14 June. Yes, similar. Yes, almost same letter, my lord. So in
14
this
June?
case,
Which one is 14 June?
14 June is in page 55.
55 is not 14 June, 7 May.
Page 55, just like that.
55 is 7th May only. The same letters.
Application. Oh, yes. Because in fact, it is not eligible in my document. It was very typed. So it is 7 June, yes. Yes, this is correct. May I read that one?
Yes. Which one?
May I read page 55 and 56. 55 and 56.
Okay.
The minutes of meeting regarding no confirmed motion against GPC. GPC means Gram.
Which one you are reading?
Page 55. The subject. May I just read the whole letter, my lord?
Yes.
Please find here with the minutes of meeting conducted on 14 June 2024 at the office chamber of circle officer Sagali regarding no confirmed motion against the.
You are reading 55 only?
Yes, sir, 55. 55 only. Yes.
Which paragraph you are reading?
Second paragraph.
Hmm.
It is also important to mention that such and such the incumbent GPC.
No, I think we are not in the same letter.
Yes, sorry.
55 page.
Page 55.
Written by member secretary. Addressed to the deputy commissioner.
Yeah.
Annexure 14.
Annexure 14 only. I'm just reading that one.
Okay. Is this letter addressed to the deputy commissioner?
Yes, second paragraph.
Okay. Subject.
Subject is minutes of meeting regarding
no. This is not the same.
Page
56 is
56 is the minus 56. 56.
Yes. Yes. You want to read the minus?
Yes. May I read the page 56?
Yes.
Page 56. May I read? Whereas a meeting was held on 14 June 2024 in the office of Chamber of Circle Office Sagali, meaning Secretary Sagali, regarding the motion of no confirmation against the incumbent Gram Panchayat chairperson of 52, the constituency is 52, Gante Panchayat, top Radhe Tara, allies Tara Radhe Tara. The following GPM from 52 Gante Panchayats were present in person for the said meeting. 1. Srimati Nangbya Namita, GPM Langpas, 1 segment is from Independent Indian National Congress. Number 2 is Nabam Lalita, GPM Langper, 11. She is also from Indian National Congress. And third is Tadar Kaga, GPM Kalapu, 1 segment, INC. 2 and 3 is from INC, and 1 is an independent candidate. The agenda for the meeting, as well as the meaning and impact of the motion, was thoroughly explained to the House President from the undersigned. House President took oath in words and in writing that they are not acting under any duress or undue influence, no cause by any way, that the decision that took were taken in full consciousness. And then last second paragraph, motion is supported by 3 out of 4, but they have not mentioned who supported and all. As for their letter, total number of directly elected members of the concerned Gram Panchayat. The whole proceeding has been video taped, and copy of the same has been duly forwarded to the concerned deputy commissioner to the email address of Pare. So this was the minutes of meeting, and after that, the deputy commissioner has confirmed by passing the interim order. Is in page 57. 57.
Okay.
May I read that one?
Yes.
Whereas a communication has been received from the member secretary 7-8 Gangte Gram Panchayat regarding no confidence motion against the incumbent chairperson, Top Radhe Tara. And whereas the procedural formalities for the no confidence motion has been duly completed in accordance with section 63(1). 63(1) is the provision for for moving the no confidence motion. It can be done by 1/3 members present and 2 of the Arunachal Pradesh Panchayat Act 1997. Whereas the motion was passed by the authority of more than 2/3 of the total numbers of directly elected members of Gram Panchayat. Now, therefore, it is hereby ordered that Top Rod Tara GPM Gram Chairperson shall cease to hold the office of chairperson with immediate effect. The member secretary of 7-8 Gangte Gram Panchayat is directed to recommend a new Gram Chairperson. This is the chairperson following the selection process for the same. So now we are challenging this impugn order being illegal, unreasonable, and arbitrary, because they are no more active member. There cannot be a merge.
Where
they
have said that they have merged.
Yes. What come है? ये page कहाँ है? Page 31. Page number 31. Page. I just take the page 31. नहीं private. March वाला what? C. B. Page in different balance. Page 31.
Yes.
Yes.
It's all the same, 55.
31 may read B. However, a copy of minutes of meeting held 21 March 2024 was submitted on 6 May 2024 by such and such General Secretary BJP organization, where stating that 3 GPM under 52 Gangte Panchayat, namely such and such 1 Tadar Kaga, 2 Srimati Nangbia, 3 Srimati Nabam, had merged with the BJP, Bharatiya Janata Party, on 21st. Your Lordship may note down 21st of March 2024. That was done on the basis of your Lordship may see page 32, the minutes of a meeting of the which is issued by the BJP General Secretary organizing Sagali Mandal unit. So that also may I read that also. This minutes of meeting dated 21/3. 21/3, you also may note down 21/3. May I read that this one? A minutes of meeting was held on 21st March 2024 at the residence of Sri Tadar Kaga GPM Balapur segment under the chairmanship of Nabam Tatum, General Secretary, organizing 15 Sagali Mandal unit BJP. The meeting was convened regarding joining in BJP by 2 INC, you also may note down, 2 INC GPM and 1 independent GPM into BJP. The House, after a threadbare discussion, has resolved the following points. The House accepts the joining in the BJP party by Sri Tadar Kaga and Nabam Nalita from Congress. 2. The House also accepts the joining in BJP party by Srimati Nangbia Namita from Independent. 3rd, the TRI had stated that they had full belief in faith for the BJP party official candidate for MLA 15 Sagali Assembly Constituency, Engineer Ratu Tichi, so that after evening he can strengthen the hand of Sri such and such Honorable Chief Minister of Arunachal Pradesh. For the House welcome the new joiner in the party and hope that they will work for the overall development of Panchayat in coming days in the capacity of GPM. The meeting came to an end after vote of thankful chat. So this was the after the alleged merge. They have been welcomed by the BJP party and they issued the minutes of meeting. Now, as for the legal position, when they have voluntarily resigned, I will talk to that later. They have resigned and they have been expelled for 6 years, but the original party. So may I take to that?
Where do we find in the act that the merger?
Yes, merger can be done in the 5A. Just take to clause 5. Merger can be done in clause 5. Page 166. 166, 5. Clause 1. May I read that one?
Yes.
Disqualification on the other side, may I read, you'll also may read, disqualification on the ground of defection not to apply in case of merger. This is the, when the merger can be valid, that may I read. A member shall not be disqualified under the subsection 1 of section 3 where his political party merges with another political party and he claimed that he and any other members of his political party. So if they want to merge, then they have to merge with his original political party from the party where they were elected. May I read A?
Yes.
A, the merger of a political party or a member shall be deemed to have been taken place if and only if not less than 2/3 of the members of the political party concerned have agreed to such merger. We are not disputing that merging is not possible. We are not saying that. But what we are, what our submission is that the merging cannot happen under section 5. Which is in the Act, section 5(1)(a), clause 2(a), which is said that they can merge, but then they have to be in the active political party. They cannot go after resign. Once they resign, they are no more member of a political party, so they cannot merge with other party. The merging is possible only when they are active member of the original political party. After merging, they can do no confidence motion. That is possible. But in our case, once they have resigned, they are no more active member. How they can merge?
No, so here in the impugn order, page 31.
Yes.
Their name has been written, and against them, it's a member of INC.
Yes.
So while they were in INC only, as a member of the INC only, this merger took place. From the impugn order, it appears.
Yes. No,
because against their name, it is written INC.
INC, but they have not resigned. They have voluntarily resigned. I will just take to that my writ petition. I will just take to the page. Your lordship may see page 29 and 30. 29 and 30. That's very important. 29 and 30. 29. 29 is a resignation from merit. 29 annexure 5 is given written by Nabam Lalita, GPM Langpa 2 segment. He has written to the President Congress Block Committee, merit subject, resignation from the primary and active membership of Indian National Congress. That is one. And same was received by the party on 17 March 2024. You also may see the extreme down left side. And another resignation letter from the INC is in page 30. Page 30, it was written by the Tadar Kaga, GPM, Balapu, 1 segment. And may I read the letter is addressed to the President Block Congress Committee, subject resignation from primary and active members of Indian National Congress, INC.
Where is the acceptance?
Yes, and then after that, the party has expelled from the membership. Is on page 34 and 35. 34 and 35. May I just 34 and 35 is the expulsion letter order. Page 34 is expulsion order issued by the chairman DAC APSCC Arunachal Pradesh Congress Committee. Disciplinary Action Committee Arunachal Pradesh Congress Committee do hereby expels Mrs. Nabam Talita GPM of Gangte 2 segment from 52 Gangte Panchayat Sagali ST constituency district from the membership of Indian National Congress Party for a period of 6 years from under the Article 29 F subclause 4 A and C of INC Constitution with immediate effect for the voluntary given up the membership of political party and deliberate action or carrying propaganda against the program and decision of the Congress
Whether
party.
this acceptance has been communicated to the
Yes.
authority?
Yes.
Well-
Now after this expulsion, the respondent, now there is a provision under section 6 subclause 1. Member of party can file a complaint against the person who have voluntarily resigned. That the concerned members should take action to disqualify.
Who
So-
member means?
Member means member secretary.
So unless the member secretary receive any information from the party concerned,
Yes.
then how would he initiate? Because here in the order of impugn order written by the member secretary,
Yes.
they are against their name, it is written INC, still they are a member, it appears, indicating.
No, it is, that's what we are, madam, our submission is that the illegality is conducted by the member secretary and deputy commissioner.
No, where is your communication after that, after their
Yes.
expulsion, where is the
Yes,
communication
yes.
to the member?
I will
secretary?
just tag to that letter. Your lordship may see, my complaint is in page 47 and 50. 47 and 50. Detail complaint, also, lordship. Detail complaint. Subject matter, just read the subject. Page 47. So written by the petitioner. Your lordship may see the intimation letter of the address to the.
This is written by?
Written by the petitioner, my lord.
No, this is written by the petitioner in the month of?
In the month of.
Thereafter only, after that?
Yes, after the expulsion only. After the expulsion only.
No. After the member secretary passed this order, forwarded it to the deputy commissioner, and the deputy commissioner has already passed order, probably.
Your lordship may see just before this complaint, there was one more complaint is in page 54. First complaint is in page 54. Your lordship may see that one.
See, just a minute. See page 55.
Yes.
This order, this is impugn order.
Impugn order is
55 and 31 is it impugn order?
No, impugn order is 56 and yes.
Okay,
Yes,
this is
55 and
just see the date. 7th May.
Page 55.
31
31.
and 55, all the same.
My lord, my impugn order is my lord. That one, no?
31 or 55, which one? Same?
Yes.
Okay.
Yes.
So see the date.
This was on 7th May.
7 May. And then see the party name against the name of the respondent. Say
Yes.
Sadar Kaga INC.
No, this is IN. Yes, Sadar Kaga is INC.
Okay, and then come to the page. Uh, 56 also, minutes.
56, yes.
14 June.
14 June, yes. This is.
No. Before, prior to that, just a minute. Page, come to page 57.
Page 57.
Order, impugn order, your impugn order. Passed by the deputy commissioner.
Deputy commissioner.
So this is on 8 June, 8?
It's the sign is on 10/7. Last bottom right side. Digital signature is there. and the date is there, 10 July 2024.
10 July.
Yes. So this is the final impugned order, because confirming the.
But you see the member secretary's letter, as you said, you have seen 7th May, and you have written this letter complaint only after that, only 11th June.
Yes, no, our complaint is just saying that it's illegal. They have to be disqualified. So it is also before before the passing of the impugned order, my lord. It has to be before the passing of the impugned order. We have filed a complaint before the passing of the impugned order. And Lordship may see this one, may see the provision. There is a provision, section 6 is in 166. Your Lordship may see page 166, section 6. This is important. Your Lordship make that one. Once they are no more.
Page 160.
166 of the Panchayat Raj Act.
Yes. Yeah.
May I read that section 6? Section 6, clause 1, sub clause A. May I read that one?
Yes.
Complaint that a member has become a subject to the disqualification under section 3 may be made by a member or a political party to the member secretary of the concerned local authority. That is one. And A, in case filing under clause A of a subsection 1, after the member gives up the membership of the political party, members give up the political party. In B, in case of failing under clause B of subsection 1, after the expiry of 15 days, see, in case filing under the section 2, after he joined the political party. So our important section is 6, 1A and 2, clause 2. Clause 2 is, may I read that one? Once the complaint is filed before the member secretary, he has to immediately forward to the deputy commissioner. Earlier it was the election commissioner, but an election commission has been substituted with the deputy commissioner. So deputy commissioner has to act within 30 days. So may I read that one? Clause 2. Where a complaint under subsection 1 is received by the member secretary, we have filed a complaint by member secretary of the concerned local authority, he shall within 24 hours from the receipt of such complaint refer the same for the decision to the election commission. But now it has been changed to deputy commissioner. Election commission shall decide the question within 30 days after receipt by him of the reference and his decision shall be final. We have filed complaint. On the basis of that, their voluntary resignation. Now I will just take to the one so-cause notice after our complaint. Your Lordship may see our this one so-cause notice was issued by the member secretary after our complaint. But after that, they have not acted. They have not acted. I'll just take to that.
Where is so-cause?
Yes, I will just show you page 36. Page 36. Page 36.
Yes.
Yes, married. To Asrimati Nabam Talita, DPM Gangte, show cause notice. Whereas a written complaint has been received by Sri Tobrat Tara GPM Gangte, you are stating that you have resigned from the party and active membership of the National Congress. Whereas it was also mentioned in the letter that you have been involved in anti-party activities. Whereas under the Arunachal Pradesh Local Authorities Prohibition of Defection Act 2023, you may be liable for a disqualification. Therefore, you are directed to present your case in a written to the undersigned within period of 1 week, 7 days from the receipt of this notice as to why you should not be disqualified as a Gram Panchayat.
So after that, only this impugned order was passed.
Yes, after that only impugned order was passed.
But next their reply also.
But then they have not acted upon this after the so-cause notice.
No, where have you annexed reply of to the so-called notice?
Your Lordship may see the date. This was the this was the date of 29 April 2020. 29 April 2025.
After this 29 April only, this impugn order was passed.
No, they,
My now query is whether you have annexed the so-called reply of the respondent.
no, my
Because
lord,
after satisfaction of the reply, only
No,
the
my lord.
impugn order was passed.
on the basis after issuing this show cause notice, no any action by the concerned members and the deputy commission. No action, no reply, no any action from that.
No,
So
that we do not know.
After that,
Okay, then
after that,
we can issue notice then.
my lord, we are praying that at least interim maybe.
No, because thereafter, you see, the so-called notice was also issued, and after issuance of the so-called notice, only this impugn order passed, and you have not annexed. What was the reply to the so-called and after so-called? So thereafter, on satisfaction, only this impugn order it appears to have passed. Must have satisfactorily explained. That is why this impugn order was passed.
No.
Otherwise, you say the notice it appears that properly issued.
No, this is a so-called notice to the respondent. you say.
That is why I'm saying, where is the reply of the reply?
My-
Reply must have
no,
been
no.
given, and thereafter only this impugn order was passed by the member secretary, impugn forwarding, and thereafter the deputy commissioner passed the impugn order. Impugn forwarding of the member secretary after issuance of this so-called notice only.
Yes.
So-called notice only. Thereafter, probably they must have submitted their so-called
that's-
reply,
in
and only on being satisfied by their explanation, only probably this order was passed,
But my lord,
and you have not annexed.
but my lord, we want to place one authority.
Hmm.
The law is, your lordship may convince, law is very clear. When they have resigned from the.
No, see,
primary
even in the
practice.
impugn order, in the impugn forwarding letter also, they are shown as INC only, not as a resign or independence.
Obviously, my lord, the authority who was supposed to act upon, they have not act upon. And then they have to pass the impugn order. So that's why we agree by the arbitrary order. So I will just show the authority. Your lordship may
Yes.
please to consider that one, because here also it talks about once they resign, because your lordship is convinced that they have resigned. Resign letter has been accepted. They have been expelled from the Congress party. Your lordship was convinced that.
See,
So once
after resignation, after acceptance, if it was properly accepted, then they would not have written this INC, member of INC.
basically, my lord, authority has not acted upon as per the act. my lord. Your
Followed
lordship.
the party and then have not accepted, that was, see, could be after explanation, after so-called notice, must have satisfied that these were the,
But this was not there, my lord. In
Okay.
fact, they have not filed any reply.
that we do not know.
That is true. May I just place the one judgment? It's of 2011. This one, volume 2, SSC 654. So your lordship are convinced that they have resigned from the political party, and this is a similar judgment. Yes, I'll just take to page. I will just take to your lordship may see the notes. Notes also important. 6 G capital G page 655. 655. $655.
Yes.
600. May I read that last paragraph, 655, last paragraph. Election of, this was the election of municipalities. Merit. Disqualification, voluntarily giving up membership of a political party. Maharashtra Local Authority Member Disqualification Act. Held is a mandatory. It operates on its own force, and if conditions prescribed therein are satisfied, the councillor stand disqualified in view of proof and admitted fact on the record of the case that appellant's councillor had voluntarily left political party to which they belong and form another party, and the legal effect would be that appellant thereby incurred disqualification under section 3(1)(a), since it was
Another formation of the another party is not shown here. That is why I'm saying.
Yes,
in the impugn order. this says they belong to, which they belong to and form another party. So if it forms another party, but then in the instant case, their name has been shown as INC in the impugn forward also.
No, they have,
Forwarding
as
letter.
per the minor meeting of the BJP, it says that, because
Minor meeting,
my lord,
BJP
my lord,
will
party
not-
formation is not before the merging, my lord. My lord, party formation is not before the merging. First, they have to be in the Congress party first, because they are they are elected from the Congress party.
Where this merging, where the member secretary has said that merge, here their names still appear as a Congress. That is why I'm saying.
Yes.
If they are still Congress merging, as you say, that is
Yes,
possible.
my lord, that's what my lord, our submission is that,
This they will dispute. You say that they have been expelled. That we do not know. Retrospective, prospective.
Expel is
yes, state anything.
So if Lordship is issuing notice only, then I have no submission at this
Okay.
stage.
in fact, may I just read the paragraph 42 of this judgment, my lord. I want just to read the paragraph 14 of this judgment. Paragraph 14. Paragraph, sorry, 42. May I read 42?
Yes.
This is a little bit, may I just read from the beginning? As mentioned above, section 3(1)(a), without any qualification or rider provides that a councillor or a member belongs to any political party or agadi or a front shall be disqualified if he has voluntarily, my lord, is important, if he has voluntarily given up his membership, my lord. Membership of such a political party, agadi or front. The provisions are absolutely in terms and are mandatory. The mandate given by the legislature cannot be ignored by the court while hearing appeals arising out of the petition filed before such and such High Court under Article 226 and 227 of the Constitution. The Land Council for the appellant could not argue before this court that appellant had not incurred disqualification in terms of section 3(1)(a) of the Act. The only contention which was raised was that the plea was advanced for the first time to the Land Council for the respondent before the Supreme Court, and therefore the same should not be taken into consideration. As observed earlier, this court is of the opinion that the court has not to investigate or inquiry into any facts in all, but has to consider the legal effects of the proved fact. The legal effects of the proved and admitted fact is that the appellant had incurred disqualification in terms of section 1(a), section 3(1)(a) of the Act, and therefore they are not entitled to any of the relief in the present appeal. So this is also important. I want to draw is that he has voluntarily given up his membership of such political party. So now I have shown you, your lordship, is in page 29 and 30. 29 and 30 is their own letter, my lord. They say that we have resigned from the politics. Yes. So may I pray that till that returnable interim may be passed, my lord.
Mr. Sunil Mo, Land Council for the petitioner. Mr. Tapi, you are for 1
to 3 Lordship.
1, 2,
1
and
to 3
3.
Lordship.
1 to 3. No?
1 to 3.
Okay. Also had Mr. Stapi, Land Senior Government Advocate for the state respondent number 1 to 3. Staff. Huh? Issue notice. Returnable by 4 weeks. Huh? Start. Huh? Since the respondent number 1 to 3, no formal notice need be issued to the said respondent. However, the petitioner shall furnish requisite extra copies to the Land Single Council or Government Council during the course of the case. Stop. The petitioner shall take steps upon the respondent number 4 to 6 by a registered post with ID within 3 days from today, within a week from today. Start. So the interim prayer is suspension.
Lordship, in interim, I have objections. Otherwise, this is a repeat case for
Okay,
dismissal, Lordship.
Okay. So then we'll fix after 2 weeks then.
No issue, no issue.
Okay, 2 weeks, returnable by 2 weeks. The interim prayer shall be.
But it has to be decided on merits, my lord. Because after this impugn order, again, this matter will be infructuous, my lord. So that's why till the returnable that that
It was issued on
because
8th of-
once the another
this,
chairperson
the
is
impugn order was issued on
8th.
10, my lord, 10/7, page 57, my lord. At least till the returnable date, my lord.
Lordship, this impugn order was issued on 8th of July, Lordship. Today is, Lordship, 18th of July, Lordship. 10 days has already passed, Lordship. We don't know, Lord, the development if taken place, Lordship. New, Lordship, chairperson might have been already, Lordship, selected, elected, Lordship. We don't know, Lordship. Then without, Lordship, implementing that party as a party in the present proceeding, Lordship, how, Lordship, interim can be considered, Lordship?
Because
that a part, Lordship. If I'm permitted to make submissions, Lordship.
Yes, please. What is? So,
because even if interim order is passed, also it can be backdated by that. Because now present is the petitioner is holding the chairperson. So once they are displaced, it will be a difficulty because we have to file fresh petition because the matter has to be decided on merit.
now you see, the order was passed on 8th July. Now today we are on 18th. We do not know what step they have already taken. Now, at this stage,
Till, as per my reliable information, till because this information we got late, until now, because the petitioner himself is chairperson, he himself is chairperson. Until now, he is still acting the chairperson, millet. Because if it is a bit affected, then the petition would have been knowing, and we would have been challenging that the final decision of after this impugn order, millet.
okay, having regards to
Because once
the
new is not
intention and the submission made by the land council for the petitioner, it is hereby provided that
once new is not made, the present petitioner always the present incumbent always held the chairperson also. So he is still the chairperson.
Lordship,
Then maybe after 1 week.
if Lordship see the Lordship section 63, Lordship, of the Panchayat Act, Lordship, what it says, Lordship? If the motion is carried out, Lordship, by 2/3 majority, Lordship, the chairperson ceases to hold that post, Lordship. There's a say of the statute, Lordship.
now what he is submitting is that since they have already resigned and they have been their membership, they are no more the members of the INP.
Lordship, here one thing.
It was another merger.
No, one aspect, Lordship.
They cannot move.
So far, Lordship, what would be the status of the members, Lordship? They would be GPC or Gram Panchayat member only, Lordship. If they gone against the law, Lordship, would that mean they automatically their membership is cancelled, Lordship?
Yes.
GPM, Lordship? No. Because issue of the merger is an independent proceeding which needs to be considered in the defection proceeding under the defection law, Lordship. That's completely independent proceeding, Lordship. If Lordship see the section 63, who is Lordship, who is the member who can move the non-competition motion, Lordship? Even if I am INC, I can move no confidence motion against my own candidate also, Lordship. But what would be the consequences? If I gone against my own candidate, Lordship, consequences would be defections law would be imposed upon me, Lordship. That would be the consequences, Lordship.
That is what he is saying, defection.
Here the defection is not the issue here, Lordship. In present read petition, Lordship, what is the under challenge, Lordship? The non-confident motion, Lordship. Not the defection. The legality of merger is not the issue here, Lordship. If they have merged, Lordship, illegally, Lordship, they can be questioned before the Lordship, the forum provided under the anti-defection law, Lordship. Whether legally merged or illegally merged, Lordship, all those the issue to be considered by the Lordship, concerned forum, Lordship. Here, if Lordship is the prayer, Lordship, non-confident motion, Lordship. Until unless the membership is Lordship cancelled or terminated duly following the procedure of law, Lordship, the state of this member would be the Lordship, is the member of panchayat only, Lordship. Until unless his membership is cancelled, Lordship, he will be entitled to, Lordship, move non-confident motion against any person, Lordship. And that is settled law, Lordship.
In fact,
If he had gone against the law and merged to some another party, Lordship, does that mean that, Lordship, he is no more a GPM, Lordship? He is a GPM only, Lordship, until unless he is terminated, Lordship. If he is GPM and he had gone, Lordship, against the person and voted against them, Lordship, against the petitioner, Lordship, and two-term, Lordship.
but law is very clear that if they have voluntarily given
Now,
out the membership of
what I'm hearing from
GPM is
petitioner, Lordship,
GPM is different.
here the clubbing together two things, Lordship. The merger and the Lordship, the non-confident motion, Lordship. Non-confident motion is the Panchayati Raj Act, Lordship.
Merging is later. First, you have to be active member of political party because you are a
Therefore,
podcast of
Lordship,
the
I'm
Congress
citing one
party.
example, Lordship. If, Lordship, is election of speaker, Lordship, if I have gone against my own party, Lordship, my membership is not automatically terminated, Lordship. For that proceeding has to be drawn under the defection law, Lordship. That authority will decide, Lordship, whether I would be still remain, Lordship, as a member or not, Lordship. Until unless that is decided, Lordship, my membership is cancelled.
We'll fix early date.
Lordship.
Here on the interim prayer on that. So
then
next week. Next week.
Yes, my lord, but then my lord,
now we really do not know what step they have already taken because it was already recommended for the appointment of the new chairperson. Friday. Next, huh?
my
Next
lord, then short date and date may be fixed, my lord.
Wednesday.
Next week, my lord, maybe.
Next week. Date.
Then Lordship, Thursday next, Lordship.
Okay. Thursday. Next Thursday is date.
But the thing is, my lord, we make sure that
25. On which date? Okay. At least this matter on 25. On which date the interim prayer shall be considered.
Lordship, that can be. Obliged.
You. Okay, that's fine.
obliged.
May I please?
Yes.
So this is
I can. Okay.
application under 227, my lord, of the Constitution of India, my lord. My lord, here, challenging the petitioner is challenging the impugn order dated, my lord, kindly turn to page number 20, Annex 2. Passed by the Deputy Commissioner Basar, my.
Page 22.
20, my lord.
20, yes.
Yes. Order, my lord. 2 Sri Nyato Basar is the petitioner, my lord.
perused the report submitted by the Sri Todak Basar at JB Village Nyagam, and the report reveals that the village authority of Nyagam village has upheld the Kebar decision of dated 16/5/2012 in connection with land in question in between Srimati Kamla Basar versus Nyato Basar. Therefore, you are hereby directed to comply the above mentioned Kebar decision without fail. Further, Sri Todak Bazar is hereby directed to demarcate the boundary as per Kebar decision 16/5/2012. My lord, what is the wrong in this order is, my lord? This, my lord, Kebar decision 16/5/2012, my lord. My lord, this order has been passed while exercising the power as a executing court, my lord.
Executive?
Executing court, my lord.
Where is this?
Deputy Commissioner, my lord.
2012.
My lord. Now, my lord, because of the recent amendment of this Arunachal Pradesh Civil Act, my lord, the Deputy Commissioner has been authorized to execute the Kebar decision, my lord.
Yes.
Yes, my lord.
Yes.
So, in exercise of that power, the Deputy Commissioner has issued this order, my lord. Now, what is the wrong and illegality in this order, my lord? Is first, my lord, this Kebar decision dated 16/5/2012, my lord. This Kebar decision, it was passed in 16/5/2012, not between, my lord, Srimati Kamla Basar and Nyato Basar, my lord, not between the present applicant as well as the petitioner, my lord. But this Kebar decision of 16/5/2012 was between the petitioner and his father, my lord.
Present petitioner.
Yes, my lord.
And his father.
Yes, my lord. Now, Kamla Basar is a, my lord, stepmother. So, my lord, I'll just give some brief facts so that we can understand properly, my lord. Some brief facts, my lord. My lord, it happens something like, my lord, that petitioner.
No, thereafter, after 16/5/2012, thereafter, has there been any case between this Kamla Basar?
No. That's why I'm coming. My lord.
Okay.
Nothing happened, my lord. Now, some brief facts, my lord, before that. My lord, this Kamla Basar respondent here, she is the stepmother. So my mother expired in 1981, my lord, when I was 3 years old, my lord. So at that time, my father, my lord, he left me and my sister, elder sister, in Basar, and he, my lord, got himself settled at this area, my lord. So this Kamla Basar, he started staying with this Kamla Basar at Dambug, my lord, leaving the petitioner and her elder sister, my lord, at the age of 3 years or 6 years, my lord. And they were brought up by my lord, their uncle, my lord. So what happened, my lord? In 2012, my lord, there was a Kebar dispute, land dispute between my father and me. Petitioner and
2012.
Then in 2012, this Kebar decision was passed, my lord, 16/5/2012. That Kebar decision which is sought to be executed now, my lord. My lord, kindly turn to page number 21 to 25, my lord.
Your father is still alive?
No, my lord. Father expired in, my lord, 2000. This after the this death of only father, my lord, this application has been filed, my lord.
After 2012?
Yes, my lord. Father expired in 2021, my lord. For 2021, father expired. So may I take to, my lord, this decision, original decision.
Yes.
English translation, my lord, will find it page number 23. Page number 3, bottom, my lord.
Yes.
2-3.
Yes.
This is a translation. Original copy is from page number 21 to 20. This is written in local dialogue. Now I will read the, my lord, this Kebar decision. It was with, my lord,
so who is this? Yumpe Basar is the father.
Yumpe Basar, my father. A complaint was filed Yumpe Basar so and so at the office so and so regarding to solve the matter so and so. The decision, my lord. After the decision was took, my lord. From the bottom, my lord. Decision made by Kebar, my lord. I'll just read this one. After prolonged discussion and also by hearing the statement from both the parties and witness, the Kebar members made a decision that Isi Riki, Paddy Field,
must be written in the name of Sri Nyato Basar. WRC land, my lord, given to me. There is no dispute as on today also. Now, next part. An area of Modi Rike Jhumkheti. This is my lord, Jhumkheti, Jhumland area, my lord. Should be divided into two parts. It said that this part has to be divided in two parts, my lord. First is that Sri Nyami Basar is the, my lord, step brother. Nyami Basar. Sri Nyami Basar 50% of area and remaining 50% to Sri Nyato Basar. So now this decision is saying that 50% should be given to the step brother, 50% should be retained by the petitioner. And Keba also passed the decision that upper portion of the Jhumkheti, which is adjacent to the plot of, should be made in favor of Sri Nyami Basar, and lower side, Christian side, should be made in favor of Nyato Basar. Now, my lord, next page, my lord. And Keba also passed that Yumpe Basar is directed to bear the half of the expenses if Nyato Basar erects or construct his new house. Now the condition is like this, my lord. This 50% of Jhumland is supposed to be, my lord, divided between the petitioner and his stepbrother.
And that this Yumpe is a father.
Yes, Yumpe
Father is directed to bear the half of the expense.
Yes. But there was a condition that, but for that, if I ever construct the residential house, my lord, the father has to bear the expenses of the half of the expenses of the construction. This is the decision.
In return of what?
My lord, in return of this 50% conditions, my lord.
Okay, given to the brother.
Yes, ma'am. Yes, ma'am.
Okay.
So this is the decision.
Okay,
then my lord, I constructed house residential building SPT Racing 2013, ma'am.
Okay.
I repeatedly approached father.
Is there any record?
So far, my lord, there is no record, my lord, so far.
Okay.
I made the statement, my lord. But my lord, when father, my lord, for the father side is, my lord, so that since, my lord, he was settled at, my lord, Dambug area, father, my lord. So he said, my lord, okay, I'm unable to give you this expenses. So you take that 50% also, man. And after that, I obtained LPC, man. LPC is in my name.
Over?
This entire area, Jhumland area.
Entire means including the 50% of your brother?
Yes. Because father failed to, my lord, fulfill the Keba decision.
No, where is that condition that if fail to fulfill, it will go to you?
Because ultimately that is the condition, my lord. It has to.
It's a 50% to 50% each.
Yes. Should be. Yes. Then, my lord, the condition is that.
No, you obtain LTC.
Yes, my lord.
Over this, both the 50 plus 50.
Yes, my lord.
Entire.
Yes, ma'am. In 2015.
2015.
Yes, ma'am. Because, my lord,
but you are not entitled for 100%.
Yes, my lord. Because when father fails to, my lord.
No, where is there any document? That's why I'm asking. Is there to show that your father failed? And then you have indicated that
admitted position, my lord, no any help was given to me.
No, you have indicated that since you have failed, I'm taking this 50% also.
My lord,
nothing.
Nothing no help was given to me. Now thereafter, my lord, then my lord will see. Then since this long period, father also never came, my lord, for claiming, my lord.
Okay.
LPC, my lord, it was father knew about this fact, my lord. All these years, father did not make any objection. Now the question, my lord. Now, in the year father dies, my lord, 2021, my lord. Then, my lord, this mother, now very question is, the mother files execution petition on 23/1/2024. This respondent, my lord. Now the question is that how this mother is not the part of the party in the, my lord, Keba decision,
Hmm.
how he can file the execution petition for the enforcement of the Keba decision which was held between the father and the son, my lord? Whether the application for execution filed by the mother can be entertained by the deputy commissioner, my lord, whether it can be enforced, my lord, because the mother is no party, is not even the beneficiary.
Not the brother.
Not the brother. My lord will find the petition, copy of the petition, date 28, my lord. Page number 28. This is 20, page number 20, annexure 5, my lord.
On what basis he is claiming?
Yes, my lord. This Keba decision, she is,
And what he says?
she is saying, my
It is
husband,
inherited, huh?
my husband, praying for execution of Keba decision dated so and so, held under the leadership so and so between. Most respectfully, I am to submit a Keba decision was held under the so and so GBs of Nyagam Place regarding the disputed between my husband Yumpe Basar versus Nyato Basar. The land in dispute is located in Nyagam village. As per the decision of the Keba, the Jum land was divided equally in 50% ratio between two parties. The decision was accepted. The present Nyato Basar is not willing or accepting to spare 50% of the Jute land for residential purpose in our favor. He is disturbing so and so. Now the question is, my lord, whether the respondent, my lord, who was not the party during the Keba decision in 2012, my lord.
Oh, then pursuant to this, what happened? What
Yes,
the
my lord.
authority-
Pursuant to thereafter, my lord, Deputy Commissioner
Hmm.
directs, my lord, the Gangura of Nigam village
Hmm.
to initiate the process of execution, my lord.
By order dated?
Order, my lord, will find my lord, kindly turn to page number 29. Then pursuant to the direction of the Deputy Commissioner, my lord, that this Keba report was submitted, my lord.
Keba report.
Keba report.
Where is the deputy commissioner's direction?
My lord, it is reflected in this report itself, my lord. May I read, my lord?
Yes, sir.
With due respect, I have the honor to inform you that with reference to the above mentioned subject, I had conducted a Keba on so and so, a dispute under the chairmanship of myself, Sri Todak Basar, with the following head GB and senior member, namely so and so on 16/5/2012. That, sir, in the earlier Keba held on 16/5/2000, board of parties accepted the Keba decision as WRC feel is in favor of Sri Nyato Basar and Jumland is for both the brothers. Sri Nyato Basar and Nyami Basar, as decision is enclosed, that today also Keba members stand the 2012 Keba decision. But there was a condition that if Sri Nyato Basar construct for his own house, then Sri Nyami Basar younger brother should have to hem him amounting to rupees 1 lakh for material collections. So today all this. Now the question is there, my lord. Pursuant to the order of the Deputy Commissioner, again, my lord, Gangura held a Kebang man. Now the question is, my lord, it's only for the enforcement of the Keba decision already that was held in 2012, my lord. Now, can it be subsequently modified, my lord, by this Keba report, my lord?
Now at that time, to help, now says 1 lakh.
1 lakh, my lord. Now very interesting, my lord. That too, my lord, without our presence. We were not called there. Now the next challenge has been put, my lord, that the original Keba decision cannot be modified at the time of my lord, execution proceeding, my lord.
What is the last? Is this a impugn order?
This is also one of the impugn order, my lord.
Okay, where is the last?
And on the basis of this, my lord, this report, the subsequent impugn order was passed, my lord. That is 25 June 2024.
Page
8, my lord, annexure 8. 31, my lord.
Yes.
Peruse the report submitted by so and so, and the report reveals that the village authority of has uphold the Kebang decision of so and so in connection with land in question in between so and so. Therefore, you are directed to comply the above mentioned Kebang decision without fail. Sri Todak Basar so and so hereby directed to demarcate the boundary as per so and so. Now, direction has been given to demarcate the boundary. Now, my lord, why this order is wrong? On two, my lord. First, my lord.
Now demarcation is 50% each.
Yes, my lord. That direction is given, my lord, to demarcate, my lord. Now the question, my lord, I have filed one representation, objection, my lord. Kindly turn to page number 30, annexure 7, my lord.
No, this order was passed on 25 June. Yours is 5th June.
5th June 2024, my lord.
After 5th June, only, this was passed.
Yes, my lord. Before passing of the, my lord, impugn order, my lord. I raise here objection, my lord, that this Keba decision cannot be executed. First, I have raised the issue of that locus of the Kamla Basar, my lord, that the mother cannot file the application, stepmother, my lord, since she was not the party. Second, my lord, now this Keba decision cannot be executed because at that point of time, my lord, that one of the condition that 50% of the construction cost, my lord, was supposed to be borne out by the father, my lord, which he failed to do. Therefore, my lord, this Keba decision cannot be executed. I raise the objection. Now the deputy commissioner, my lord, has not considered my objection, not discussed about my objection, not heard me, and without affording the opportunity of hearing, my lord, has directly, straightly passed this impugn order, whereby direction is given to demarcate the land. Now, my lord, the grounds, my lord, on the basis of which this impugn order has been put to challenge is, my lord. First, my lord, this execution petition cannot be entertained. First, my lord, that entertaining the execution petition itself, my lord.
Will issue notice?
My lord, then, my lord, as on today, my lord, no any action has been initiated, my lord. That's why, my lord, till that, my lord, this my lord, this impugn order, my lord.
Because here, your letter also, you have given your own explanation saying that because this was not a condition, 50%, only on the payment of the or father, if the father help, then only he'll give 50%, which was not a condition.
Well, it is the, my
Your
lord,
notice.
it is there, my lord. Now the question is, my lord, that first, my lord, this.
No, this was also not condition.
My lord.
Anyway.
Now, my lord, question is that, my lord, subsequent Keba cannot modify the earlier Keba decision. It has been modified, number, my lord. Execution petition.
They probably has taken the present rate only, 1 lakh.
My lord, they cannot do, my lord, because law says, my lord, how the, my lord, that too, my lord, without.
But then you have also not shown that he did not help, or you have asked for any help, or you have constructed any house or building.
No, my lord, I have made a statement in my affidavit, my lord. I have made my statement.
Mr. Arsenal, I counsel for the petitioner. Stop. This is an application under under Article 227 of the Constitution of India for setting aside and quashing the impugn order number LRD/LK 176/2023 2024/33 dated 25/6/2024 issued by the Deputy Commissioner Basar, directing the HGB Nigama NYIGAM Nigam village to demarcate the boundary as per the Keba decision dated 16/5/2012 and further directing the petitioner to comply with the Keba decision dated 16/5/2012. Start. issue notice, not returnable by 4 weeks.
Well, till date, my lord, otherwise, my lord, this matter will become infectious. my lord.
The petitioner shall take steps upon the respondent by a registered post with AD within a week from today. Staff, huh? Where is the impugn order, sir?
My lord, page number 31, my lord.
Whether we do not know, it was passed on 25 June.
My lord.
Now you see we are.
No,
in
nothing
July.
has been done, my lord. I have made a
Now,
statement. As on today, my lord, no demarcation. My lord, I have not been heard even, my lord. At least, my lord, I should be heard. My objection should be considered. My everything has to be, my lord, without violating principle of nature. How this order can be passed? Straightly, my lord. That too, my lord, for implementing of 2012 decision, my lord. And I have the LPC also.
having regards to the contention and the submission made by the land council for the parties, it is hereby provided that if the authority has not demarcate the boundary in execution of the order dated 25/6/2024, the same shall not be done till the returnable date. Okay.
Deeply.
Yes. May I please?
Yes.
My lord, GR case number we have got 218/19.
Okay. You. Okay, pardon, Mr. N. Rama, land counsel for the petitioner, staff. Also had Ms. T. Jini, learned additional PP for the state of AP, staff. This is an application under section 482 of the Code of Criminal Procedure 1973, praying for quashing of the FIR, quashing of the GR case.
GR case 218, my lord, 18/19.
218.
218/2019.
2019.
Yes.
Pending before the
Learned Court of JMFC.
Learned
UPR.
Court of JMFC, UPR,
UPR.
arising out of
FIR dated 1/4/19, my lord.
Domestic PS case number 13/2019 under section 447 324 IPC. This is quashing petition.
Yes, my lord.
Joint petition.
Joint
No?
petition, my lord.
Then you say- in the beginning, you said, right, this is a joint petition file, file under section. Okay.
Victim accused and informant, they have jointly filed, my lord. Victim accused and informant, they have jointly filed, my lord.
Victim
accused and informant. Complainant, yes. One petition number 1 is accused, 2 is a complainant, 3 is a victim, my lord.
Okay. It's fine, okay. Stop, huh? Issue notice returnable by 3 weeks. This is which case?
My lord, till then,
We'll be needing the
processing may be
scan copy of the
we have to be
TCR.
considered.
Scan copy of the TCR.
Okay, call for the scan copy of the,
TCR, your lordship.
okay, TCR. Huh? Trial court record, huh? Staff, huh? Since Miss Jeannie, Planet Additional Advocate has accepted notice on behalf of the state. No formal notice need be issued. Not list this matter after 3 weeks.
My lord, till then proceeding may be stayed, my lord.
You have not even.
I have made prayer, my lord.
Hmm?
I have made prayer, interim prayer, my lord.
You see, you have not
Matter is
even
fixed
inserted
for-
the number also, nowhere in your petition. See? Nowhere.
The stage of the
My lord,
proceeding.
I have made interim prayer, my lord. Proceeding before the trial court may be stayed, my lord, till returnable date, my lord.
Hmm?
Yes,
Okay, so, but you see, you have nowhere you have mentioned.
in fact, your lordship, that's what, they could have at least annexed the last proceeding, your lordship, because we're not, since this is a 4-year-old matter, we are not aware of at what stage.
Because how would we know?
Matter is in evident stage, my lord.
You could have annexed at least one order.
Yes.
Or you could have mentioned the case number also of the JMFC. That. Okay.
In the trial court, my lord, it speaks on 6/8/24, my lord. 6 August 24.
In the meantime, the further proceeding of the GR, what is the number?
218/19. 218/19.
No, 2019. Before the judicial magistrate first class UPR shall remain state till the next returnable date. Okay.
Highly obliged.
Just a minute, Mr. Uveriti, in item 3, Nipajati Roy and Mr. P. Ete is present. Oh, Mr. Ete, here what we have seen, we'll fix it for order for tomorrow.
Okay, your lordship. Okay,
The order will be passed tomorrow only.
okay, your
because,
lordship.
This is AB,
Yes, your lordship.
so
You-
that way, no?
Yes, otherwise your lordship has called for the case diary in this case.
No, that is a, so the case diary will be called for tomorrow only. The order will be passed tomorrow only, not yet.
And tomorrow, your lordship, I would like to apprise this, because tomorrow personally, I won't be able to present. I have some.
No
personal-
problem, because order only.
Okay, your
Order,
lordship,
because
no issue.
the order, we did not pass order today.
Okay, your-
So order will be passed tomorrow.
okay, deeply obliged.
Okay. So only the paragraph which we have written, that will be shortened, saying that the list is tomorrow for order.
Okay,
Okay.
okay,
Okay.
deeply obliged.
Your lordship, we have already submitted our additional.
Affidavit,
Yes, your lordship.
where? Additional affidavit file.
Yes, your lordship.
It is not on record. Okay. Where have you given the present address?
Sir, it's in rent agreement.
Hmm?
Rent agreement. We have annexed the rent agreement.
And it's what?
Rent agreement. She's in rent right now. Unique. This is different, I guess.
Paragraph 3 of the affidavit, Lordship, address is given at Papunala.
There are three.
Sorry, sir.
Where is your present address?
Here, present address we have given in the annexure number 1 of our additional affidavit, Your Lordship.
Where?
Yesterday.
The paragraph?
It's in paragraph agreement of first
title.
yes, first address.
No, in the course title, your permanent address is Longding only.
Where, Your Lordship? Not that one, Your Lordship. We have filed one additional documents. Today, yesterday only, Your Lordship. That is a different, I guess. That is a different file, I guess, Your Lordship. We have filed one.
Where is the new one? Additional affidavit file.
Additional affidavit.
No, this is old one.
They don't mean. Okay.
Just a minute, huh? Okay, just a minute. Yes. Wait, okay. Sure. Got it. Okay.
Yes, Your Lordship.
Okay. Miss Jongluju, Lana Council for the petition.
J. Jongluju.
J. Jong.
Yes, sir. J. Jongluju.
Jongluju.
J. Jongluju.
J. Jongluju, Lana Council for the petitioner. I've also heard Mr. Tapak. T. Tapak, Lana Council for the respondent. Stop. Para. The petitioner filed this application on the section under Article 227 of Constitution of India, read with Section 24 of the Code of Civil Procedure 1908, praying for transfer of KSA/TS within bracket DVR bracket close number 04/2022 filed by the respondent against the petitioner pending before the court of before the district court Tirap. To the district court to the district court UPR. Stop. Where have you stated that you are married, Para?
Yes, Your Lordship.
Where have you stated that you are married or with the petitioner
Yes, in the month of September 2024,
Well,
in their
paragraph,
it's page number 19, para 9, 3, para 3, page number 19,
page number,
19, 119, Your Lordship.
okay.
Point number 3, para 3.
Yes.
In the main petition,
Hmm.
19, page number 19.
The petitioner is married to the respondent in the year
2004, Your Lordship.
2004. Okay. 2004. And out of their said marriage, how many children?
Two sons.
Okay.
No.
They have two sons. However, due to the discord developed between them, the husband respondent has filed a divorce petition before the district court concern, which has been registered as ASA/TS DBR number 04/2022. Start. And now the petitioner and the respondents are staying separately.
Yes, Your Lordship.
Separately. Stop. Para. The land council for the petitioner submits that the petitioner had filed domestic violence. Where is the case number?
Of domestic violence, sir? It's in page number 52, annexure A2, page number 52.
Case against the respondent, which was registered as DB case number 3721 under section 12 PW DB Act. However, the same case before the Chief Judicial Magistrate UPR in the year 2021. So the petitioner has also filed a maintenance application before the Chief Judicial Magistrate first class. Where is the number?
57, page number. Annexure 5.
For maintenance of wife and children under section 125 CRPC before the Judicial Magistrate first class in the year 2023, which is still pending before the said court. Stop. And this divorce case was filed when?
It's we have received it on 15th of December 2022, Your Lordship.
22.
Yes, 16/1 15th 2022.
Okay.
15th December 2022.
It is the further case of the petitioner that the respondent has filed a divorce petition before the district court concern against against the petitioner in order to cause harassment to the petitioner. Although the petitioner, although the respondent very well knows that the petitioner is stationed at Itanagar. Stop. The Land Council for the petitioner further submits that the respondent, the petitioner is a housewife.
Yes, Your Worship.
And cannot afford to go to Longding to attend the court, and also at UPR to attend the court before the GMFC for maintenance petition. As such, prays for transfer of the above divorce case from Iraq to Itanagar, South. Iraq to Itanagar, South. It is the further case of the petitioner that the respondent is working in the police department.
Yeah, it's
as a
yes, Your
constable.
Worship. It's a constable. He is a constable, Your Worship.
He's a constable and he is stationed at Itanagar.
Third,
And as such, no prejudice will cause to the petitioner if the case is transferred to from Iraq to Itanagar. The Land Council for the respondent, on the other hand, submits that the petitioner has left.
Oh, shit.
Petitioner has left herself.
Yes.
Okay.
Left the home.
Left at her home. And deserted, you say?
Deserted.
Deserted the
Deserted
respondent. And at the moment, she doesn't have any address. And at the time of filing of the divorce petition, the petitioner, the respondent was staying at Longding. Therefore, the said divorce petition was filed at Consa. At the jury Consa. Stop. Heard both the Land Council for the parties. Having heard both the Land Council for the parties, and also you have referred some cases.
yes, Your Worship.
Yes. Okay. Having heard the submission made by both the Land Council for the parties and also on perusal of the materials on the court, it appears that the divorce case earlier number, the KSA TS DBR number 04/2022 filed by the respondent is pending for trial before the district court, Tirap. Stop. And I submitted, being the woman, the petitioner who is a mere housewife, cannot travel from Itanagar to Longding and from Longding to Itanagar to attend another case pending before the JMFC Itanagar, UPR. On So under the circumstances, if if the said divorce case is transferred to the court of, from the district court Tirap to the court of, district court UPA, no prejudice would be caused to the petitioner, since the petitioner, so cause would be caused to the respondent, since the respondent is serving in the police department and posted at Itanagar, and their children are also studying at Itanagar. Under the circumstances, the court is of the opinion that this is a fit case to transfer the said divorce petition from district court Tirap to the district court UPA in the interest of justice. This is Rajani Kishore Pardesi.
Yes, Your Lordship.
Okay. In support of case, the respondent and the petitioner
Petitioner.
relied upon the case decided in Rajani Kishore Pardesi versus Kishori Babulal Pardesi, reported in 2005 12 SCC 237, wherein the Honorable Apex Court held that while going into the merit of transfer application, the court are required to give more weight and consideration to the convenience of the female litigants, and the court should desist from putting female litigants under undue hardships. Stop. Therefore, the convenience of the wife is to be preferred over the convenience of the husband. Stop. Accordingly, this transfer of TS DBR within bracket DBR on number 04/2022 on the file of the district court Tirap is hereby withdrawn and transferred to the file of the district court UPA. Stop. The district court Tirap shall transmit the entire record of TS DBR number 04/2022 pending on its file to the court of the district court UPA, Papumpare district UPA, forthwith by duly indexed. Stop. This transfer petition is accordingly allowed and disposed of. Okay. The parties are directed to appear before the transferring court. It should be the August 30.
30 August.
August 30. Okay.
Deeply obliged.
Yes. Yes.
May I please, my lord. My lord, I am appearing for the petitioner, my lord. Here, this criminal petition is for quashing of the FIR. Other than on merit, my lord. One of the grounds that has been urged in this petition for quashing of the FIR is the inordinate
Quashing
delay.
petition.
Yes, ma'am.
Yes, ma'am. Just a minute.
My lord,
Yes, my lord. The CD was called for, my lord.
Okay,
I have submitted the CD, my lord.
this is also joint petition,
No, no, my lord.
not joint petition.
Not joint. It's against the causing of the FIR in SIC case, man. The complaint was lodged in 2018, my lord.
Okay,
And till date, my lord, nothing has been happened, my lord.
Hmm?
Till date, nothing has happened, my lord.
okay.
So one of the grounds other than the merit is that there is an inordinate delay in the investigation. So it is affecting me, man.
It is still in the.
No, 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 my lord. Therefore, my lord, I have submitted the CD, man. In
This
fact,
is
my lord.
CD?
Yes, my lord.
2018.
2018, my lord.
Offense under section
No, my lord, the
409.
yes.
420. Okay, PC Act.
My lord, as per the record submitted by the investigating agency, my lord, the matter has been, the investigation is closed, my lord. It has been submitted to a final report, my lord. No prima facie charges have been found against the alleged.
Final report submitted.
Yes, my lord.
Okay, then.
Therefore, my lord, this may be recorded, my lord, and then the,
Final report already submitted.
yes, ma'am.
And pursuant to that, the court did not pass any order.
No, my lord, the investigation, we have closed the investigation, my lord. We have not found any prima facie allegations against the accused persons, ma'am.
There is no prima facie case
Yes.
against accused.
Yes, my lord.
Then whether the IO file final report.
As for the document which I have submitted, my lord, I have submitted the CD, my lord, which I have
Just a
received, my
minute,
lord.
This was submitted on May 24.
16 July,
So
my lord.
pursuant to this, whether the learned court has passed any order.
No, my lord. In fact, my lord, as for the document which I have received, my lord, it was submitted on 21st of May 2024, my lord. The next page, my
Automatically,
lord.
there is no case against you.
Yes,
The court will pass order discharging you
Therefore-
automatically.
No, my lord, that I was not aware, my lord, but
Ah.
today my brother is submitting that. But
Hmm.
in fact, I was informed by the agencies also. So we have checked with the court below, my lord, learned court
Yes,
below. But
it will be better
it has
because-
not been filed till date, my lord.
No, my
No,
lord,
no,
if-
it's already forwarded. 21/5/24.
20 and 5 years.
This is final report only. So nothing found against you.
Therefore, my lord, may record this statement, my lord, and then the petition can be disposed, the criminal petition can be disposed of.
Well, otherwise, my lord, if they have already said in the fact that there is no incriminating material against me, my lord, then this can be disposed itself, my lord, on the basis of this FIR. Because, my lord, since
Otherwise,
due
how
to
many
the
accused here in this case?
2, my lord.
2. So this petition is only in respect of one.
only in respect
Two.
of one,
Both.
one only,
Only one.
only one.
So there is nothing against both.
No, because the allegation was of siphoning of the government funds, my lord. But the allegation was about siphoning of the government funds,
Okay.
my lord. But during the course of the investigation, it has been found that the work was done and the work order was issued only for the work which was constructed, my lord. And there is no any findings of misappropriation of government funds, my lord. If my lord turns to page 6, my lord, the last para, my lord. Page number 6 now. Mr. Finding one.
Yes. So this is what, however, complainant may persuade the department to claim his rest bill. Okay, so this is not against the petitioner.
Yes, my lord.
Otherwise, my lord, those works, my lord, those works were, because there's a report also, my lord, by a technical committee. The report was also clearly says that no tender, etc. was floated for the works. But other than that, there is nothing. And those those works, my lord, those were awarded by the earlier incumbent. I joined after the works were awarded and the work was going on. In fact, in the complaint also, the complainant has also said that works were awarded by the then executive engineer. I've only paid the bill only. So well, if there is, if it is on record by the agency, investigation agency, on that ground, my lord, saying that this can be disposed of, saying that no material has been found. Because, my lord, one of the ground is that I am an engineer, my lord. I am 56, now, as of now, I'm almost 56 years of age now. My promotion is also being, career progression is also been affected because of this SIC case, my lord. If there is nothing there, my lord.
You were arrested also?
No, no, my lord, not arrested.
Suspended?
No, no, nothing, my lord. But since there is I am made accused, my lord, my career progression, my lord, it's also been affected.
Now, without setting aside the FIR, we'll just direct the special judge, PC Act, to pass necessary order.
Yes.
Hmm?
In accordance with law, my lord.
Okay. Okay, hard, Mr.
This okay.
It's okay. Line counsel for the petitioner. Stop. I've also had Mr. the special PP, no? Oh, but line special PP. Special PPP, PC Act. Stop. By filing this application under section 482 of the Criminal Procedure Code 1973, the petitioner prays for quashing of SIC stroke VIZ stroke PS stroke case number 08 stroke 2019 under section 409 420 120 within bracket B capital IPC, read with section 13 within bracket 2 bracket close PC Act. Your ground was that it was nothing has been done.
Nothing has been inordinate delay, my lord.
On the ground.
Yes, ma'am.
That although the FIR was lodged when?
6/7/2018, my lord.
On the ground. That although the FIR in the instant case was filed on 6/7.
6/7.
Where do we find?
My lord, that is at page 31, my lord.
31
Yes, ma'am.
was filed on 6/7. Twenty 18. Case was registered on that day.
That, my lord.
Where do we find that the case was registered?
Case has been registered in 19 only.
Where do we find the date?
That date I do not have, my lord, but the case number is from 19, man.
Okay, which was registered is SIC register in the same year. Same year.
Yes, my lord.
No, my lord.
Same year.
It is registered in 2019. my lord.
2019.
Yes, my lord. Number 8 of 19, my lord. FIR number 8 of 2019.
FIR number 8 of 19. Date 2019. Which was registered in the year 2019. Which was registered as FIR number 8 stroke 2019. Oh. 19. Nothing has been done. Till date, done by the eye of the case till date, start. The case that is called for has been received and I have perused the same. Start. On perusal of the record, it appears that the FIR was filed on, let's say, same date, 6/7.
6/7.
2019. And the case was registered. And the same was registered as SIC VIG PS case number same, what you have written above, case number 18, 819 under section so and so. When this application was filed?
This application was filed on 7 December 2023.
23?
Yes.
Okay. However, but the investigation, but the investigation of the case was still pending. No, but the case was still under investigation. Stop. However, after filing of this, the filing of the instant petition, praying for quashing of the said FIR, said FIR dated FIR number 8 stroke 2019, the office, this was filed by not by the IO. It is by the officer in charge.
Yes, madam. Officer in charge.
Not by the IO.
The IO has been transferred, my lord. in the
Okay.
meantime, yeah.
Yes, the officer in charge, This is officer in charge, SIC, which, within bracket, VIZ, bracket close, PS Itanagar. Submitted a final report of the said SIC VIG PS case number 8, 2019, under section so and so, entire, start. On 21/5/2024. Start, The final report says that there is lack of evidence against says that although the investigation was carried out, however, there is a lack of evidence against Alice accused is an engineer.
Yes, ma'am.
Okay. There is accused. As there is no any pecuniary gain found in their account. Their accounts, comma, in their kit and kin, kin's accounts, comma. And further that no any conclusive proof to suggest that any fund was siphoned by the alleged accused without work or less work, as work was done in sleep clearance. Stop. In view of the above, comma, and since the case has already been submitted into final report, comma, I propose to dispose of this remaining petition with a direction to the special judge PC Act UPR, where the charge is, where the final report has been submitted, to pass necessary order into the said final report.
Madam.
You can't direct also to discharge. As, in accordance with the law. Okay, within a period of 30 days. No. After submission, normally if they might also give chance to the informant around 30 days.
1 month time.
Within a period of 45 days from today.
The time period may not be given, my lord, because automatically
pass necessary.
in accordance with law will do. my lord.
Okay, with about this criminal petition stands disposal. Okay.
Obliged.
Return the case study.
May I on?
Yes.
Your Honor, this matter may kindly be released by this honorable court and fix it on Monday, Your Honor, for hearing.
Monday.
I've taken consent from the respondents.
Okay. So then entire effort goes.
Because if it is fixed after 4 weeks, then it'll be the same thing, Your Honor.
Okay.
It'll be like starting the matter afresh.
Then, okay, both the land council for the petitioner, Miss Sering, P.Y. Bhutia, Land Council for the petitioner is present. And Miss,
Tirini, on
Okay.
behalf of PICA.
on behalf of Mr. Peter for Land Council for the respondent is also present. So it is prayed for by both the Land Council for the parties. List this matter again on
Monday.
Monday.
22nd, I believe.
Okay. Monday is 22nd. Okay.
Deeply obliged. Your Honor, this matter may be passed over for some time. On behalf of Mr. Dicky Pangin, this matter may be passed over for some
Yes,
time.
which one? Item?
10,
Then pass over for?
for some time, Your Honor.
No, I think,
He's just
what
gone,
is this matter about?
he's just gone out for a minute. I've been requested by
Is it
him to
urgent?
pass over.
Okay, pass over for the time being.
Deeply obliged.
Yes.
Exactly, the Lordship. I am from Guwahati.
Yes.
In item number 11.
Item 11.
But here in this case, a friend, public prosecutor earlier occasion raised one objection that my lord, friend of the petitioner swear the affidavit of the application. Though it is permissible by the High Court rule, but without going to the controversy, my lord, I have filed one additional affidavit swearing by all the petitioners before your lordship, ascertaining the fact and circumstances under which my lord they are my lord compelled to file this application before this honorable court, my lord, through my lord their family friend, my lord, who swear the affidavit, my lord. I have stated in the paragraph, my lord, 5 of my additional affidavit, my lord, how they filed this petition through their my lord family friend, my lord. And this matter is otherwise, my lord, compromise between the parties. And to this effect, informant already filed one affidavit before your lordship that he has no objection if this honorable court is pleases to, my lord, allow
This
this.
is AB
bail.
only. This is AB.
If I may brief your lordship,
Hmm?
this is the case, your lordship, if remembers that on behalf of all the accusers, for accused, your lordship, some another person has filed an affidavit in the anticipatory bail application, your lordship. That was the objection being made by the prosecution's office.
Okay.
Now, since they were not cooperating in the entire investigation
cooperating now.
after granting of the bail, your lordship,
Okay.
we have filed an IA wherein we had prayed
Just a
for,
minute.
we had prayed for cancelling their
Cancellation of the bail.
no interim bail order.
Interim.
Yes. Since they were in during the pendency, they were in interim bail
Now,
order.
are they cooperating now thereafter?
Thereafter, because your lordship has not called up for the updated CD, your lordship. On 2 occasions, the issue with regard to the affidavit was argued on, your lordship.
Now, your contention was that the petitioner themselves did not sign the affidavit.
Affidavit, your lordship. It was
Now it appears that they have signed their affidavit.
no,
They appeared before the court.
no, your lordship. They have filed an additional affidavit.
In the additional affidavit.
They're bringing into relevant, more relevant facts, your lordship. They filed an additional affidavit, your lordship, wherein
What is this additional affidavit? It's for?
I have filed, my lord, from my lord, learned friend, one additional affidavit, my lord.
So what is this about? Well,
my lord, at paragraph, my lord, 5, it is clarified, my lord, under which circumstances, my lord, they have filed, my lord, this petition, swearing an affidavit through their, my lord, family friend, my lord. Though it is, my lord, in the, my lord, as per, my lord, High Court rule, it is permissible, my lord. The person having, my lord, knowledge about the facts and circumstances of the case can swear the affidavit, my lord, though he or she is not petitioner
No,
in
no.
the
Our
petition, my lord.
contention is that even after obtaining interim anticipatory bail, the accused did not cooperate or participate in the investigation
My lord, with all
and did not never
respect,
appear before the eye of the case.
my lord, with all respect, my lord, though, my lord, there was no direction in the interim order to appear before the IO, my lord. Nevertheless, my lord, petitioners before your lordship admittedly and willfully, my
Case
lord.
there is not there.
Case
No, my
that
lord.
is there, your lordship. It's the updated case that he was not called for thereafter, your lordship. After those objections were placed. If your lordship, if I may, your lordship, if I,
Just a minute.
my learned friend, let me at least apprise this court of the facts, your lordship. Your lordship will see that this was, the IA was filed only on the instruction of the honorable court, your lordship, because they on every update of the CD, your lordship, there was an statement saying that they have not come even after calling them through telephonical communication, as well as
Wait for some time. Wait.
as well as
Always, my lord,
Hello, wait.
as well as telephonic communication, as well as by issuing notice under 41A as well as 91C, your lordship. So since the CD were always available before this honorable court, there was a suggestion being made that since they are in interim, your lordship, and IA has to be filed praying for cancellation of their interim bail application, your lordship. We have submitted all the notices after the granting of the anticipatory bail, your lordship. We have submitted all the notices that were issued to them, calling upon them to cooperate with the investigation, your lordship. One of the prime factor for filing of this IA was also that the vehicle that was used.
Please don't disturb, please.
The vehicle that was used by one of the accused, your lordship, on repeated request, the vehicle was never produced. Thereafter, your lordship, only a statement was, only an information was given that that vehicle has been, your lordship will kindly notice that during the investigation of this case, the vehicle has been sold to some other person whose details were also not given to the investigation officer.
Just a minute. By the order 29-5, it was directed that the applicant would appear before the IO of the case on or before. Whether they appeared.
Your lordship, that record is not available, your lordship, because.
And then it clearly says even the opposite party, the applicant do not appear on or before so and so. This court on the next date would consider the conduct of the applicant while considering the issue. Now, updated, no. Okay, it was on 6. Updated, you were directed to produce updated CD.
Yes, your lordship.
Parties list this matter again on 18. 26, this matter again on. No, so there was a direction that you need to produce updated CD. So in the last order, 26/2024, list this matter on. It was to be listed on 16/7.
Yes, lordship.
On which date the additional PP shall produce the updated case tariffs.
Yes,
You are not ready with updated.
your lordship, thereafter we have
No, see.
though the
this-
status report
this
does
is
not.
Last order probably. This is the last order.
15 to.
It was on 26.
Yes, your lordship. This is the updated, your lordship.
Yes, fixing 16/7.
Yes.
You have.
Yes, I have, your lordship. 15/7. The last updated CDs of 15/7, your lordship.
Okay. Whether the accused appeared.
There is no reference as to their appearance, your lordship. There is a order of the honorable court reflected in the CD, your lordship. However, the status that they had appeared is not available in the CD, your lordship. 4/6.
So your ground for this cancellation is only that they did not appear.
They did not
They are not
appear.
cooperating.
They are not cooperating, your lordship. Now, meanwhile, during the pendency of this application also, Your Lordship, they filed another criminal petition under 482 for quashing of the FIR, Your Lordship. That is also pending before this honorable court, Your Lordship. Now the
Subsequently,
subsequently, Your Lordship,
not after this or prior to this?
after
application?
this, Your Lordship.
Okay. So this is AB
In
only.
fact, this is AB only, Your Lordship. And in fact, if I'm not wrong, Your Lordship,
If they are cooperating, then
they're not
They are
cooperating.
hearing-
Therefore, I was coming to Your Lordship with that, Your
what
Lordship.
is the comment of the IO? Can we just see the
Yes, Your Lordship.
last?
He has specifically reflected the involvement as well as their non-cooperation, Your Lordship.
Hmm.
Your Lordship, if I may read, Your Lordship.
Yes, please.
Akram Hussain Mazumdar, a prime accused, remained at large, still not arrested. Your Lord. Efforts going on for his apprehension. White Bolero car so-and-so linked to the crime registered under Kaji Taibur Rahman, not seized. Kaji Taibur Rahman, uncooperative. Rupees 89 lakhs recovered or frozen from 2.02 crore cheated. Rupees 1.13 crore still untraced. Focus on establishing money trail for recovery. Investigation is in the earliest listed. Now,
this subsequently the informant, according to the Land Council for the petitioner, has received those money
yes,
and rest amount he has undertaken to repay.
yes. My only
Now this is money transaction only.
no, Your Lordship. My only because there are provisions of penal law, Your Lordship.
Hmm.
My only concern with regard to this case is that can an agreement be a ground for bail? An agreement can always be a ground for quashing of the FIR, so and so. Now, their agreement itself reflects that there was a cheating, Your Lordship. If Your Lordship will see the agreement, and if Your Lordship remembers the agreement annexed in the quashing petition, Your Lordship, that certain amount has received. If the certain amount does not receive, another legal action can be shall be taken. Now, my concern on
Now you see. Otherwise, this is the civil case.
yes.
The first question would be why you have registered.
No, no.
When you knew that this is a
No,
civil
no,
case.
this is not a, I completely does not concur with Your Lordship that this is a civil case, Your Lordship. Your Lordship will see
Only because
just
the case has
because
been
there is a
registered.
transaction of money does not in any way make it a civil case, Your Lordship. The action of the person has to be taken into consideration. Firstly, the accused came in
It
a
is
car.
only you see, the informant has made an allegation only to extract or to get back his money. And then you have been utilized, the police.
No, no, no.
If you knew that this is the money transaction between two parties, why you have registered?
No, Your Lordship. If Your Lordship see the entire brief of the case, Your Lordship, out of the 5%, Your Lordship, of the transaction, therefore I'm stating that action of every individual has to be seen, Your Lordship. Your Lordship will see one of the male servant of the prime accused. He comes and he states that he is a priest and makes certain statement that he'll be getting the work. The other accusers, Your Lordship, after receiving the money, they shares, Your Lordship. The vehicle which was used in the crime, Your Lordship, has never been brought before the police officer.
But now the informant is no more aggrieved.
That's not a part of that's not a ground for concern in bail, Your Lordship. My only concern is can a compromise before Your Lordship is well aware why is the prosecution and the investigation being a part of this state entity, Your Lordship. Once a FIR is being filed, it's a case between the accused and the state, Your Lordship. Now, can an agreement be a ground for quashing? Bail has to be taken into consideration and taken into the merit, Your Lordship.
Yes.
May I please, Your Lordship?
You are not cooperating. So
My Lord,
they are playing for.
definitely, my Lord, they are cooperating, my Lord. There, my lord, these petitioners are not main accused, my lord.
Record reveals they are not cooperating, they are not appearing before the eye of the case.
Cooperating, therefore, my lord, paying, my lord. Precise allegation is that, my lord, they were main accused, my lord, took some money to give contract work, my lord. And when, my lord, he failed to contract work, he had not returned the money. And, my lord, after filing the FIR, my lord, full amount, my lord, it is paid, my lord. And matter is amicably settled and the informant submitted affidavit, my lord. He has no objection.
Whether the bail was executed, interim bail, have they surrendered?
Yes.
They surrendered.
They
And release also.
Yes, I have.
Then what?
No, I have briefly written in my statement, Your Lordship, in my IA, Your Lordship, that they had come before the IO after granting of the interim bail, Your Lordship. Execution of the bail was done, Your Lordship. Now, after execution, what are the
After execution, because you see, before execution, you must have recorded their statement on
No,
461.
no. Until unless they are in AB, Your Lordship. After getting the interim bail only, they had appeared.
No.
Before
Getting obtaining interim bail only, they appear before you.
Yes.
For you.
Yes.
And you must have recorded their statement.
Yes.
What more?
Yes. Now,
What more you
if
want?
I may, Your Lordship. Now, Your Lordship is well aware that the investigation starts not only on one statement or one statement of the witnesses, Your Lordship. Your Lordship will see after execution of the order, they have left the police station stating that they have some urgency. On the another date, they will come for giving their statement, Your Lordship. If I may take Your Lordship to.
Actually, my lord, they are from Hailakandi, Assam, my lord. And lady and government servant are also involved, my lord. And
Now,
they
if
are
Your Lordship will come to page number 14
Only
of my IA, Your Lordship.
kindly, landed people, kindly, I may be allowed, my lord. My lord, only suspicion is that some money were recovered from their account, my lord.
Just a minute,
And-
just a minute.
My lord, my lord.
Your sounds little trouble. Page 14.
Yes. This is the execution order, Your Lordship. After.
Yeah, this is bail bond.
Yes, bail bonds, Your Lordship. After granting the interim order, they have executed this bail bond, Your Lordship. Now, if Your Lordship will come to page number 6 of my IA, Your Lordship.
Yes.
If I may read paragraph 8, Your Lordship.
Page, para?
Para 8 of page 6.
Yes.
The applicant deems it pertinent to mention here that pursuant to the interim bail, the respondent appeared before the investigation officer on 22/3/2024, and after execution of the bail order, since the respondents on the said date requested the IO for some time to record their statement, the same was allowed with a view to give some time for recording of the statement as desired by them. Further, they were served with notice under section 91 of CRPC on the day of execution of bail order to produce documents relevant for investigation or on or before 26/3/2024. However, respondent did not turn up on the said date. That on being contacted telephonically to appear before the IO, the respondent replied that they would appear before the investigation officer once the bail is of the prime accused so and so and so and so will be out on bail.
No, do you have
Now-
the 161 statement of the accused?
Your Lordship,
Just like it.
Your Lordship will then come to page number.
No, do you have the 161 statement of the accused?
Yes, Your Lordship, I have in the CD, Your Lordship, because since I cannot annex it in my petition, Your Lordship.
Yes, yes.
The same being confidential, Your Lordship. The very next
Can you
paragraph,
just pass it? Can you
very
just
next
pass it?
paragraph, Your Lordship will see at page number 7. Page
Para?
number 7, Your Lordship.
Para?
Para 9.
9, okay. Yes.
That since so and so failed to appear after execution of the bail, the IO having no other option had issued a notice under 91 CRPC read with section 41A CRPC on 4/4/2024, directing the accused to be present on or before 7/4/2024.
Okay.
The respondent appear on so and so.
Respondent appeared on?
7/4/2024.
Okay, then?
And their statements were recorded under
Then what
section.
more you want?
Yes, Your Lordship will see that even if a statement is recorded, Your Lordship, he is not discharged of the duty because the investigation is still in process, Your Lordship. Now, under 161, they accepted to the fact that they have taken the money, transacted money to their account. Now they have not been able to give the account details, Your Lordship.
It will be trouble. See,
They cannot be
they
released.
appeared, you have recorded the statement of the accused under 161 also,
Yes,
and then thereafter, subsequently thereafter, immediately,
Yes.
probably the party has come into agreement.
yes.
And thereafter, you see, what more you want?
Your Lordship,
161, you have already recorded. You
yes,
want
they're not.
custodial interrogation thereafter.
Your Lordship will see, my non-incorporation means that they have not been able to, Your Lordship will come to.
No. Money was paid to the party directly thereafter.
Your Lordship will come to page number 23 in that case, Your Lordship.
It cannot be paid through police. Page number?
23, Your Lordship. Your Lordship will come to third paragraph, Your Lordship, and whereas you are directed to appear before the undersigned.
Page 23.
Yes,
It's a
Your
notice only.
Yes, Your Lordship. Since they were not appearing, we had issued notice.
This was issued on?
23 or 4/4/2024, Your Lordship.
Dated 7/4.
No. 4/4/24, Your Lordship. Page number 23.
Page 23.
Yes, Your Lordship.
This is a notice under 91.
91 and 41A, Your Lordship.
91.
And 41A.
This is dated 7/4, I could see.
Page number 23, Your Lordship.
Yes, page 23 only. Notice under section 91 CRPC. Is
Above-
7.
7th is the next date when he was
On the
called for.
7, on the same day, the accused appeared before the IO and recorded their statement under 161.
Yes, on the.
Yes.
No. Your Lordship will see on 7th, 28 page number, last page. On 28, page number 28, 7/4, that is dated 7/4, Your Lordship.
28.
28 page number, Your Lordship.
This is 4/4.
No,
28.
In the-
Your IA.
my IA, Your Lordship.
This is 24. On 24, on 4/4 also. Thereafter only the accused appeared before the IO.
On 20. This has wrongly been paginated, Your Lordship. It has wrongly been paginated, wrongly annexed, Your Lordship. It has wrongly been annexed, the date.
Okay. What is the right?
In that case, Your Lordship will kindly come to page number 28 first, Your Lordship.
28.
28 or 28, Your Lordship.
28 is also notice 91.
Yes, that
Under
is
91
dated
and
4/4.
41 CRPC. So this is also dated
4/4/24,
4/4/24.
Your Lordship. Now, if Your Lordship will come to paragraph third paragraph, Your Lordship.
Yes.
And whereas you are directed to appear before the undersigned on or before so and so with direction to produce all relevant documents to submit claims upon deposit money and record of the statement there. However, you were failed to appear before the undersigned without any prior information. So they were also asked to produce relevant documents because the transaction has not only gone to one of the person's account, Your Lordship. Now, if Your Lordship will then come to page number 23, Your Lordship.
Here, see, he was asked to appear on 26/3. Now thereafter only they have already appeared.
Yes, therefore, Your Lordship will come to on 7/4/2024, Your Lordship.
Hmm?
Page number 23.
Yes, 7 also.
Your Lordship will see even if they had appeared, the notice was again issued under section 9 after recording their statement. Why? Your Lordship will kindly see this notice, Your Lordship.
No, on 7, yes.
Yes.
On 7 they appeared.
7, Your Lordship will see after they had appeared and they have given the statement, notice again under 91 CRPC was issued. Why? For the given reason, Your Lordship. Second paragraph, Your Lordship. And whereas it revealed in the course of investigation that the Bolero car bearing registration number so and so used in commission of belongs to you and required for purpose of investigation of the instant case. Hence, you are required
See,
to
your
produce the
statement was recorded on 7 only.
that's
on
after
the same day.
After this, it was issued to them by hand, Your Lordship. Why? Because Your Lordship will see on that day when on 4th when notice was given, Your Lordship. He came on 7th to give his statement, Your Lordship. On 7th, he did not bring the car that was under investigation, which has on many occasions where he was directed to produce that car, Your Lordship. So on 7th, after he has given his statement, Your Lordship. On 7th itself, a notice was issued that giving the next date that on so and so date, you need to produce that car, Your Lordship.
So you mean to say that on 15/4 they did not appear?
15/4 they did not appear, Your Lordship. And therefore, Your Lordship will see, and therefore the direction of this Honorable Court to appear on 29/5, on 4/6/24.
Yes, after last appearance on 7/4, you were again asked to appear on 15/4. You did not appear. This is the allegation against you. So thereby, that way you are not cooperating. Because you were asked to produce the document.
My lord, they literally admitted their guilt and unfair activities. Therefore, matter was, my lord, amicably settled, my lord. And Lordship kindly have a look at the allegation. Allegation is that, my lord, as main accused, my lord, that is, my lord, their elder brother did not return the money. Therefore, my lord, he, on apprehension, filed the, my lord, FIR, my lord. And these petitioners are his family members, my lord, and including lady, my lord, and government employees. One of the petitioner is doctor, my lord.
How they are family? You say that they are from Assam, they cannot come to Itanagar. How they are family?
They are the, my lord, family members of the main accused, my lord. And, my lord, this matter was amicably settled, my lord. And they are amicably settled means, my lord, he is admitting his guilt, my lord. And money is also returned, my lord. And informant submitted the affidavit that, my lord, no objection. And he has received the money, my lord. My lord, learned friend, my lord, making the allegation that, my lord, for investigation, my lord. If, my lord, accused admitting the guilt, my lord, and matter is amicably settled, my lord. And which is, my lord, also, my lord, accepted by the informant, my lord. And this is a purely, my lord, as per allegation, that is a monetary transaction, my lord. And Lordship, when granted, my lord, the bail to the main accused, my lord, your Lordship specifically observed in the, my lord, bail order, my lord, that this is a monetary transaction between two friends, my lord. Therefore, I am granting bail, my lord. And, my lord, they are from Hailakandi, Assam, my lord, and there is a group of people, my lord, 4 persons from the same family, my lord, and they are, my lord, time and again, my lord, appeared. But still, my lord, I admit, my lord, sometimes, my lord, I have perhaps, my lord, called them, my lord, but they, due to, my lord, long distance, they who may not come, my lord, in time, my lord. But nevertheless, my lord, so far necessary, my lord, they appeared and their statements are also recorded, my lord. And Lordship, another thing is that, my lord, how far they are fair, my lord, as per interim order, there was no direction, my lord, to appear before the IO. Nevertheless, my lord, they willfully and voluntarily appeared before the IO and executed the interim bail, my lord.
And there is a subsequent order. You
Yes,
were
my lord.
directed to appear before the IO of the case.
Yes,
Subsequent
my
order.
is that, my lord, here in this case, my lord, where, my lord, they have accepted their guilt, my lord, and matter is amicably settled, my lord, and informant is happy with the, my lord, the accused person, my lord, that he has no objection. Therefore, my lord, your Lordship may, my lord, may consider that their custodial interrogation in this case may not be necessary, my lord. This is my humble submission, my lord. When, my lord, this thorough investigation and inquiry, etc. is required, when, my lord, matter is not, my lord, admitted by the accused, my lord, when matter is amicably settled, my lord, literally they have admitted their, my lord, unfair activities, my lord. And, my lord, here in the precise allegation in the FIR is that, my lord, this friend, my lord, took some money from the informant with the assurance that he will provide, my lord, government contact to him, my lord. And if he does not, my lord, provide work, he will return the money within week, my lord. When he did not return the money, my lord, then only, my lord, he filed the FIR. This is his, my lord, civil type allegation, my lord. And they are otherwise, my lord, they are tenant and landlord, my lord, and they are good friends, my lord. And in the meantime, the matter is amicably settled, my lord, and admittedly, my lord, informant submitted the affidavit that she has received, my lord, 2 crore 20 lakhs, my lord. So he has no objection if your lordship is pleased to, my lord, consider the rest file, my lord.
Mr. You are Mr.
A.M. Borbi, my lord.
Learned counsel for the petitioner. I've also heard Ms. Chinny. Learned additional PP. State of AP. Staff. Is directed. Is directed. The petitioner has filed additional affidavit. Signed by. This petition was joint petition was filed by 4 persons.
4 persons.
Okay. All the petitioners. The case diary is called for. The updated case diary is called for. Has also been produced, and I have produced as well. So, as per the record. The accused applicant has appeared before the eye of the case on 4th also they appeared. It appeared.
No.
Okay. On 7th.
On 7th.
Appeared before the eye of the case on 7th. They were. Where is the bail bond?
On 22/3.
In the main. Okay. Yes.
Yes. 14. Page number 14. You know.
Okay. No. The accused appeared with all the accused persons appeared before the IO of the case on 22/3/2024. On the same date, on which date the accused, all the accused persons were arrested in connection with the Chimpu PS case number 11/2024 under section 120B 420/409 IPC staff. However, on the same day, all the accused persons, namely, what are the name? Kaji Abibur Rahman. Kaji Tayyabur Rahman. Sultana Begum is also accused.
Sultana, yes, Your Lordship. He
Sultana Begum Majumdar.
He is the wife of the main accused.
And Sri Kaji Abu Bakr. How did I started this sentence? Last sentence. Okay, on the say date, all the accused person, namely so and so, were arrested, huh? And on the same day, they were released on interim release on the strength of the interim anticipatory bail granted to them on when the interim anticipatory bail was granted to them
On 14/3/24.
to them on 14
3/24.
3/2024. Stop. Huh? The record further reveals that no, 14/3/24 on execution of the bail bond. Huh? Stipulated in the said interim bail. Huh? Stop. Huh? Stop. The record further reveals that thereafter thereafter where is the notice? So, yes, yes.
Your Lordship, a notice starts from 20.
Thereafter, huh?
20, Your Lordship.
On notice issued on them. Yeah, in just a minute. Thereafter, in compliance of the notice issued against them, all the accused persons appeared. Again appeared before the IO of the case on 07/04/2024. So on the same date, the IO has recorded the IO had examined and recorded the statement of the accused under 161 CRPC. Stop. The above record shows that goes to show that the accused persons, after obtaining the interim anticipatory bail, has been cooperating and appearing before the IO of the case. Okay. The line counsel for the petitioner, the accused applicant further submits that subsequently, as the money, as the case involved case is a monetary dispute between the parties, the matter has amicably been settled between the parties.
Your Lordship, if I may just interfere for a moment, Your Lordship.
Yes.
The agreement is only between the prime accused and the
whether this agreement has been
not signed.
forwarded and informed to the IO of the case. Hello, Mr.
My lord.
Whether the agreement entered or executed between the parties were informed to the IO of the case.
I have also instructed them to one copy to send to the IO, my lord.
No. What did you say?
My lord, I have instructed them, my lord, this same copy want to be, my lord, forwarded to the IO, my lord. I have instructed them, my lord.
Whether they have given forwarded?
This is, my lord, not informed me, my lord.
Then how would the IO know?
My lord, they will submit, my lord.
Lord Counsel.
My lord.
The order was passed, you see, it was from April, and then you said that it was the agreement entered between the parties when? And then you have not yet informed the IO also.
My lord, it is, my lord,
it will be difficult.
Yes, my lord, this is during the pendency of this, my lord, bail, my lord, it is executed, my lord.
Well, I counsel for the petition submit that during the pendency, this sentence will be during the pendency of the case, is the matter involved with the monetary dispute between the parties. The matter has amicably been settled between the parties. And the same would be
Your Lordship,
by executing agreement.
Your Lordship, Your Lordship.
Settlement agreement.
If I
Yes.
may just
Yes.
interfere, Your Lordship. The settlement was not done by these parties and the complainant. It was done by another party, Your Lordship, whose name is given as Kaji Habibur Rahman. He's totally he seems to be the main accused, Your Lordship. So if Your Lordship reflects that the settlement was done by the complainant and the
Where is the agreement?
My lord, agreement, my lord, informant submitted in with my lord with his my lord affidavit, my lord. And my lord, I may clarify, my lord, these petitioners are my lord only family members. My lord, police recovered some money from their account, my lord. Therefore,
The agreement was entered with the informant or with somebody?
my lord, as per FIR main accused, my lord, who took the money, my lord.
Main accused and?
Yes, my lord, Habibur Rahman, my lord. And my lord, these petitioners are my lord.
Just wait. The agreement was entered between main accused and
my lord, informant, my lord.
Informant.
Informant, my lord. As per allegation, who took the money, my lord?
So, Your Lordship, if Your Lordship is dictating, Your Lordship, if Your Lordship reflects the settlement, Your Lordship, if Your Lordship just reflects that it was between informant and the main prime accused, Your Lordship.
My lord.
Informant and?
The prime accused.
Prime accused, my lord.
Because this applicant here are not parties to
Okay,
the.
by executing settlement deed between the informant and the prime accused. In view of the above, and as the accused persons are cooperating and appearing before the eye of the case for further investigation of the case, the I'm of the considered view that the interim anticipated bail granted to the accused applicant on
14/3/2024. Interim bail was granted on 14/3/2024.
How? It was on 8/4.
Interim was granted on 14th.
So what is this 8/4?
8/4.
Continued, my lord.
8/4 is to Kaji Habibur.
That is the prime accused, Your Lordship.
Prime accused.
That was in another case, another AV.
Regular agreement.
Okay. 14. 14/3.
14/3, Your Lordship.
Is hereby regular agent made absolute, with the same terms, on the same terms and
Your Lordship
conditions.
if I may, Your Lordship, on 14/3/24, Your Lordship, they were only asked to appear before the IO within 10 days, Your Lordship. If Your Lordship will see the bail granted, Your Lordship. That's in my IA.
This 14/3/24 is the interim bail.
Yes, interim bail.
There was no provision to appear, even then they appeared, my lord.
Your Lordship will see the petitioner shall appear before the investigation officer within 10 days from today, Your Lordship. That was the condition given, Your Lordship, along with the bail bond of 25,000.
Okay. This is only interim bail.
Yes, this is
on
only
execution go on interim bail on execution of 25,000 with the further condition that the petitioner shall appear before the eye of the case the petitioner shall cooperate and appear before the eye of the case on eye of the case, as and when called for. Appear and make themselves available for interrogation, available for further available for further investigation of the case before the eye of the available for further investigation of the case, and as and when required. Okay. Number two, that the accused applicants shall not directly or indirectly make any. There is no condition, so that is
Yes,
one,
no condition, your lordship.
any inducement, threat, or promise to any person acquainted with the fact of the case, so as to dissuade him from disclosing such fact to the court or to any police officer. That the accused applicants shall not commit the similar nature of offense as they are alleged of. Commission of the suspected offense.
Lordship, my IA may also be disposed of according to the order passed.
Yes, stop. With the above this application stands allowed and disposed of stuff. In IA, in view of the order passed in the AB 41 AP 2024, this IA stands disposed of.
Deeply applied.
I'm deeply aware.
Right, sir? Yeah.
I'm sorry, my lord, I was on late in court number 2.
Yes, no problem.
Item number 10, my lord, this matter was filed on 1st of July when this new CRPC came. So there was some confusion, my lord. So, but that I understand that confusion is no longer there. My lord, we issue notice, my lord.
Governed by the earlier CRPC.
Yes, has to be.
Yes. So
no order was passed on the last occasion, only fixing today. Because there was some confusion because it came,
okay.
Nobody came prepared.
This is criminal appeal.
Yeah, criminal appeal. It's a statutory appeal, my lord will issue notice.
Okay.
Respondent number 2 through the maybe through the jurisdictional police station.
Mr.
Through the PP.
Deepang, Land Council for the petitioner. Stop. I've also had Miss Hage, L Hage, Land additional EP, state of AP. Stop. Para. This is an application. No. Okay, this criminal appeal. By filing this criminal appeal under section 372(2) of Code of Criminal Procedure, the petitioner has assailed the judgment dated 10/6/2024 and order of sentence dated 10/6/2024, convicting the appellant for offense under section 363, 323 of IPC, read with section 4 of the Boxer Acts 2012. Stop. He is in jail in execution of the sentence. What is the sentence?
7
Terms 7 years. Okay.
and 20,000.
Okay. The appeal is admitted. Call for the trial for record. Stop. So issue notice returnable by 4 weeks.
No, notice be routed through the London PP.
Yes, since Miss.
Lordship, to the office of PP Lordship.
Hmm?
To the office of
Uh,
PP Lordship.
Accepted notice on behalf of the state respondent. No formal notice required to be issued to the state respondent. How the not victim. No?
Yes, victim.
Okay.
Gun name.
The petitioner should take steps upon the victim through the
The office of PP Lordship.
office of PP.
Lordship.
Okay. Through the office of PP. Father, okay. Within a period of within a week.
By Monday I will give.
Okay. Monday means within 5 days from today. Stop. At least this matter after 4 weeks.
Yes.
Okay.
Notice in the IA also, same order in the IA also.
In the IA also. IA is for
Matter suspension of sentence.
stay off.
Yeah.
Okay.
Notice matter, same order.
Okay. Hard, huh? Same, huh? And this is an application under section 389 of the Code of Criminal Procedure, praying for suspension of sentence and realization of fine during pendency of proceeding and grant of bail to the accused applicant. Staff, huh? Issue not notice.
Rest same.
Returnable by or same,
Yeah.
huh? Last one, the same.
Yeah.
Okay.
Obliged.
My lord, only that 164 statement was called for.
Okay, yes.
My lord will peruse and pass the
Yes,
order.
yes.
And there is no argument, nothing as such.
Right, right.
And my lord, only request I make. My lord,
Whether
is-
the
I think.
164, have you received? Yeah.
Lordship, is it there in the record Lordship? The registry has called the record Lordship.
Next.
Okay.
Oh, okay, okay. Then, my lord, only one small update only. On 16, this is fixed for 16/9, it has been fixed for cognizance. Appearance, huh?
Yes.
Appearance. The accused persons who are seeking bail, the court seems to have taken cognizance of the matter and they are asked to make an appearance on 16/9.
16/9.
Yes. Well, just I furnish a copy for that. Only
16/9.
Yes, September.
We are
We
in the 7th.
we are in July.
July.
Yes.
Lordship, Lordship, there's a provision in the POCSO Act, this section 35 Lordship, regarding the period of recording of evidence of trial and disposal of case Lordship. Here, the Lordship, the evidence of trial shall be recorded within the period of 30 days of the special court taking cognizance of the offense and
Yes,
reason of
that is
delay.
right, that is
Clear,
right.
Lordship.
Mm.
Lordship, there's spirit
Probably
trial.
we may have to direct to
Lordship.
prepone it.
Lordship.
Prepone the
Because before
evidence.
Lordship, recording of the statement of the Lordship, victim's Lordship, it is not appropriate this court to grant bail at this stage Lordship.
If she is making argument, my lord,
Lordship,
again, I will.
I'm just assisting this
Yeah.
court Lordship. I'm doing
On
my
that day-
job Lordship. I'm
On
just
that
assisting
day,
this
we
court
made a
Lordship.
submission, we
Okay,
said
no,
no more argument,
no,
only
please,
164 statement.
Just a minute. What is the name of the? This is 164 of.
That all the accused person.
Yes, yes.
Hey, Jitla. My lord will only take all this, my lord, peruse 164 and
Yes,
other
just-
material
just
records.
let me see.
And then only my request is, my lord, all the judgments, my lord, all the judgments, my lord, I have cited may also be recorded in the order, my lord.
Cited judgment.
Yes.
And
Lordship,
I don't know whether that will be recorded.
Lordship, may I have, if Lordship permit, Lordship, I have just Lordship, want to Lordship.
Name of the accused is Bama Prosi, Tayo Prosi,
This, yeah.
whether the victim has taken the name of these three persons.
Lordship,
It's
it's
there.
their, TIP is also their lordship, as well as statements are their lordship.
EIP is also there.
Lordship.
It'll take me time, since you have seen. Could you just mark?
Lordship.
Yes. Mm. Mm. Taking the victim statements also, it will not complete in 3 months. There are more than 30 plus accused.
Accused.
30 plus accused. 35, 36. My lord will only excise.
So we are not concerned with the other accused, we're concerned with only three accused.
Yes. The others, my lord, I think learned a special judge really refused the bail of around 12%. 12%. Trial, my lord, I have a very good case. Trial, I have a very good case.
Trial, yes, maybe, but we do not know. At this stage, we can't say. It's very difficult sometimes. It's okay, just mark when the victim who has taken name and the PIP.
Well, she can mark and hand over to my lord, and my lord will peruse thereafter because there is no more argument.
Yes, no more argument.
If someone takes the risk of arguing, it will be at the cost of one peril. We also know how to deal with people.
Lordship, now my senior is trying to influence the court, Lordship. It is not permissible, Lordship. I'm sorry, Lordship.
We do not know who is stronger.
She should mindful of the judgment, the functioning of the public prosecutor.
Lordship,
If
actually,
that is the
Lordship,
case,
I'm duty bound, Lordship.
I can-
I'm not, Lordship, I'm just assisting
Duty
the court,
bound
Lordship.
beyond the
Sometimes
cable
it
of
may-
argument.
Sometimes it may not be the age or the seniority, but maybe be
That's it,
depends on case. Please. No.
That you take others. Well, CWC has recorded the statement. Okay.
They have taken some other name, in somewhere, you can't make out also, who is this?
Lordship.
You did not mark.
Lordship, actually, Lordship, this is a bail matter, Lordship. Generally, they at this stage, Lordship, what, Lordship?
No. I'm trying to find out the name, if
Lordship.
they have taken.
Lordship, name is there, Lordship.
Name is there.
Lordship.
The same name in the FIR. Oh, sorry, same name.
Lordship. Because they have not sent all the lordship. There is many lordships. They yet to lordship. They have examined before the special court also. That's why I am submitting lordship. At this stage, bail should not be granted. This is
Where we have already submitted.
lordship. This is
just
only
answer-
164
just
lordship.
Answer
Lordship.
the query. Submission we have already made. Statement is there,
Lordship.
but then this is scan copy only.
Lordship can copy.
Okay.
Lordship.
And this is PIP.
Lordship.
What is more painful in the painful before the special court is we have applied for Milord certified copy of all the documents, but that's are not we have 2nd July Milord we have applied, but we have not been provided Milord. There is an inordinate delay in supplying this document to us. Okay, on 2nd we applied.
Just kindly help marking, huh? Highlight it with a pencil. Name of the accused.
Lordship.
Please.
Lordship, usually lordship at this stage, lordship, there is not relevant
yes.
for this lordship.
I haven't
Not
seen.
examine
I haven't
lordship.
seen the name.
Lordship.
Okay, then the order will be passed.
Yes, sir. He's now, yeah. I think post list निकाला था. Malad, this Malad, today is 18, no?
My lord, in item number,
Just a minute, huh? Okay, so this record had Mr. T.T. Tara, learned counsel for the petitioner, huh? Stop. Also had Ms. L. Hage, learned additional PP for the state of AP.
Serial wise होता ना.
And Ms. S. Bidara, learned legal aid counsel for
Mail
the
number
respondent number
58
2. Stop, huh?
सोलह 67 माथा वो निकल कितना दिन हो गया. ये 67 days हो गए. Before no. This is over. Here, 68 plus 70 days. 14 minutes. 14 and 70 days.
The case of the petitioner is that basing on the FIR lodged on 4/5/24 by one Tabaji, Chairperson CWC ICC, Itanagar.
My lord is passing order. My lord is passing order.
Yes, but then rest, I'm just, in the meantime, I'll pass order in the chamber.
Okay, my lord. That's
So, Lordship, may Lordship, before passing order, I have a small line, Lordship. Lordship, just to assist the court, Lordship, it's not, Lordship, I am submitting, Lordship, beyond the law, Lordship. Lordship, for the Lordship, just to assist the court, Lordship, it's not relevant at this stage for the court to examine the detailed evidence of the record, Lordship.
That we know.
Yes, Lordship, this is a matter of trial, Lordship. And moreover, Lordship, before hearing the Lordship, while hearing the bail matter, Lordship, the court has to keep in mind the nature of the accusation, Lordship, the nature of the evidence in support thereof, the severity of the punishment, which punishment will be entitled to the accused,
That you have
Lordship.
already submitted.
Lordship, that's why, Lordship, in regards to that, Lordship, here, Lordship, the victim, Lordship, their safety is very secure, Lordship. That's why, therefore, Lordship, from the beginning, I am submitting just to assist the court, Lordship.
Yes, that
These are very, Lordship, this is a very initial stage of the trial. So maybe, Lordship, at least, Lordship, the victim's state may be recorded. After that, court may pass any order, Lordship. At
That
least,
also
Lordship,
you have submitted. I've
Lordship,
noted it.
Lordship,
Mm.
Lordship. That's why, Lordship, I just, Lordship, applying this court, Lordship, once again, Lordship, kindly, Lordship, this submission may be recorded, Lordship.
But have you marked the name of the accused here in
Lordship, it is there, Lordship.
Hmm?
Lordship, it is there, Lordship.
So in the statement of the first victim, she has not taken name. Second has taken name of. Now, how do we link with this one? Here name is different and then accused name probably is different.
Lordship may pass any order, Lordship. Just my humble request before the Lordship is dead, Lordship, kindly record my submission,
No
Lordship.
point, you have already submitted.
Lordship.
So I'm looking for the name only. Try to understand.
Lordship, I have already, Lordship, it is marked, Lordship, I have marked.
I just need to confirm. Who are these persons? Name is placed. No. Name of the accused here is different. Probably. You just tell me whether
Lordship,
the
name
same
is there,
name they have
Yes,
taken
Lordship,
or
same
they
name
have
is-
taken different name.
No, Lordship, same name, Lordship.
Same name.
Lordship.
Short name.
Lordship. Lordship, can Lordship,
How do
PIP,
I-
Lordship. Lordship can go to the
Huh?
PIP, Lordship also.
Hmm?
PIP also is there, Lordship. Name is there, Lordship, identified by the victim persons.
See she has taken name Makte. Which one is Makte?
Lordship, that's why Lordship, this is a matter of trial, Lordship. Let the examine before the trial court, Lordship. We have.
How would I link the name of the accused and the statement here?
Lordship, that's why Lordship, I have
Who
marked
is
Lordship.
Makte is,
Marik,
in which-
Lordship, maybe Lordship, this some typographic mistake may be there, Lordship.
No, no.
Marik, Makte, Lordship.
Try to understand. I'm
Lordship.
just trying to clarify myself.
Lordship.
The accused name is here different. Mari,
Lordship.
and the other one is.
There are two accused, Lordship. Toy Bagra,
I just
Bulang Marik, and
They
Lordship,
have
one
taken
Nilam
name.
Tamanga, Lordship.
Makte. I don't know who is Makte.
Lordship,
Makte
that's why
is
Lordship,
accused.
Lordship, it is there, that's why Lordship, I just Lordship marked it, Lordship. The name is this, there,
Just tell me,
Lordship.
do you know who is Makte? Which accused is?
Lordship,
Accused
how
in
can
which-
I know, Lordship?
Hmm?
How can I know, Lordship?
Oh, that is why I'm asking you. If you don't know, then how do I find out their name from this statement?
Lordship,
You say that they have taken name. You have marked Makte. I just wanted to confirm, Makte is the accused
Lordship,
in
there's no
59.
way Lordship Makte name is there, Lordship. Maybe Lordship the Marik they have Lordship wrongfully they have
There-
written the
How
Makte.
many accused are there?
Lordship accused names are there, Lordship.
As of now, Milord, 28.
28 accused.
28.
Out of these 28 accused, who is this Makte? Makte is the accused in the 59, 60, or 58?
No, no, Lordship. It's not their name is Marik, Lordship. Marik, Bulang, one Toy Bagra, one in
Any
Nilamanga.
one of them has taken this Marik Pulang and
Lordship is there, Lordship. Bulang, Toy Bagra, and Nilamanga name is there. You, Lordship, may see other pages also, Lordship.
where have you marked? Have you marked?
Lordship,
Bulang is there.
Lordship.
So where is the other accused? You have marked Makte. Makte is who? Which
Lordship,
one?
that's why, Lordship, I am also confused, Lordship. Who is Makte? Maybe Marik they have written as Makte because the same Lordship, the other Lordship, other pages their name is Marik, Lordship. Only one Lordship, victim Lordship, Makte, Lordship.
There I wanted to confirm, nothing else.
There's no more victims, Lordship. The only one victim has called Makte. I don't know, Lordship. That is matter of Lordship trial, Lordship. They will examine there also.
Because unless they stated against the present accused, it will be difficult. So that I wanted to find out if they have taken their name. And you are submitting something else. Only for that, whether they have taken name of this accused or not, this 164 statement was, because from 161, we could not.
Lordship.
164, I just wanted to confirm.
My lord, may I make a small
Just
suggestion?
a minute.
A small suggestion, because my younger colleague is not in a position. So therefore, like, let the learned
Lordship,
public
Lordship,
cross-
here, Lordship, I am not Lordship, I am not enabled to examine Lordship all the records, Lordship, because Lordship, this is out of
In
my
that-
hand,
in
Lordship.
that
I am just
view of
assisting the
matter-
court regarding the bail, Lordship.
Correct, correct. In that view of the matter, let the PP assist you and find out.
No, she has marked. So this, she has marked, and then how do we link? Who is this?
There must be code name that we do not know.
Because Makte has committed, and then if we could link this Makte as, if this Makte is any one of these accused, that I wanted to confirm. Okay, so.
Well, only days, number of days.
Now the PP is not ready to tell.
No,
So
sir.
it will, so I have to decipher them. It will take me time.
No, sir.
Anyway, so I'll pass order.
Yeah,
No,
my
sir.
lord, only kindly number of days in bail application number. Item 12, my lord. Item 12, 67 days. 67 days.
Okay.
In incarnation. Then in item 13, it is 66 days.
Item
13.
66 days.
66 days. And item 14, 70 days, my lord. In that, my lord, coordinate bench judgment.
Okay.
It was
So in,
only in 55 days.
just a minute. Item 12, what is the name of the accused?
Item 12 is a B. Marik. B Marik.
B.
Marik.
B stand for?
Bulan.
Peter DSP Lordship, Bulang Marik.
Okay, and then this 13?
13 is Toy Bagra. Is as constable.
Okay, and then 14?
Is a former ZPC. Former Jila Parishad member.
No, name.
Name, Mangha.
Full name?
Neelam Mangha. Well, that's why I pointed out this only in view of the order passed in by the coordinate bench. The same sections will not after filing on the charge. Others will not, I made submission only because satisfy the court and I'm not advancing any argument.
1 minute. Okay. Sorry. Okay, order will be passed. Okay, next. Just a minute.
Please, Your Lordship.
Yes, just a minute.
Oh, sure.
Please. Yes. Give it to the chamber, huh? So,
my lord, before the
this also.
before
Yes, this was.
before my brother Nair and the learned public prosecutor start the submission,
Yes.
I only request my lord to record paragraph 6 of the bail applications below. Where the
Which one?
In this item 14,
14?
15, 15, 15, item 15.
15.
Yes, kindly see paragraph 6.
My lord, the allegation, my lord,
This
the
is
438, my lord.
438.
438.
438. My lord, allegations and the FIR starts from page 12, my lord. It's an FIR dated 3rd of July 2024. My lord, the informant, my lord, she is a TGT in Government Higher Secondary School. She's aged 32 years.
Record was called for.
Yes, my lord. My lord, I sought for the case diary and I have the book.
Yes, yes. Case
It's
diary.
a case of consensual relationship. My
Yes,
lord,
yes, we have seen.
my lord may come to page 13.
Except for the allegation after that. Otherwise, it was a consensus.
It was consensual.
Consensus. Yes.
The only thing, my lord may come to page 13, para 10 of the FIR of the information. Page 13, my lord.
Page 13?
13 of the FIR. Paragraph 10 of the FIR.
Yes.
On 36/24, my parents came to know about my pregnancy, resulting I attempted.
Only because I wanted to see, because on that day it was submitted, it was forcefully.
No, my lord.
She was forced to terminate. I
No,
just
my-
wanted to see that part. It's not dated 15/7/2024. List this matter. After,
Maybe after 4 weeks, this matter, Your Lordship.
after 4 weeks, stop. Mr. Lani PP is present, huh?
Deeply obliged.
ADPP, huh? Okay. Yes.
May I plead, Your Lordship? This matter 19/20/21 is the analogous matter. item number 19 is for rehabilitation of compensation component under the LARA Act. We are praying for that. They have not been paid. They have been rehabilitated, but then the compensation component which was supposed to be paid under the LARA, they were not paid. And that is 19. And 20 is praying for the solution. They have been paid compensation, but then solution was not part of the award and paid.
In the, just let us take up one by one then. 19.
19, yes.
So 19 is ready for hearing.
No, they have not filed basically the
Affidavit
important.
in opposition file on behalf of respondent number 4.
Yes, your lordship, we have filed our affidavit.
Yes, and what about the others?
Only number 5 also.
5 also filed. And what about 1, 2, and 3? Okay. Land Council,
Your lordship,
Mr. Sunil Mo, Land Council for the petition is present.
5, yes, they have not filed. 2, 1, 2.
Mr. You are Mr.
2,
you
3
are-
will be important party.
Yes. Yeah, you are.
Vairidam, your lordship.
Hmm?
Vairidam. For 1 and 4.
1 and 4.
Yes, your lordship.
Where is present on behalf of the respondent number 1 and 4. And Mr.
For respondent number 5.
Namely, your name?
Roop Tichitara. Roop Tichitara.
Roop
On behalf of Tavata.
Tichitara. For on behalf of
Tava Tagum.
Taba
Tagum.
Tagum Land Council for the respondent number
5.
5. Okay. No one appears on behalf of, sorry, both. The respondent number 4 and 5 has already filed affidavit. However, the respondent number 1, sorry, for 1 also you have filed.
No, your lordship, we have only filed for 4. 1, there is.
Okay, 1 to 3 are
Your
yet to
lordship,
file. In view of the above, list this matter after 3
After-
weeks, 4 weeks,
3 weeks.
3 weeks.
2 and 3 has to file. They have not yet filed the counter affidavit.
That is right.
Yes.
2 and 3. Okay. And then in 20 also same.
20 also same.
Okay, similar other than. Huh?
Yeah.
Okay.
19, 20, yes.
Okay. 21. Okay.
Apply.
Your lordship.
Yes.
Lordship, this is a petition for condonation of delay in filing an appeal against the order of judgment.
You have it. Who is the respondent?
Your lordship, I am for the respondent.
Opposite party number?
No,
there is
only sole respondent.
Sole respondent.
Yes.
You have any objection?
Only there is 4 days delay.
4 days. Okay. Yes, hard, Mr.
No objection.
This is item
Item number 22. your-
22. Okay. Hard, Mr. Kato.
Jika.
Ji Kato, Land Council for the applicant. So I have also heard Mr.
K. Posi.
Land Council for the respondent and the opposite party, huh? This is an application under section 5 of the Limitation Act 1963 for condonation of delay of 4 days in filing the appeal against the impugned judgment and order dated. Filing the connected appeal against the impugned judgment and order dated 16/5/2023 passed by the Learned Civil Judge Senior Division UPR in title suit number 36/2017. Stop. The delay in filing the connected appeal has been explained in para number 2 and 2, 3 and 4 of the
Para
petition.
3.
Stop. The opposite party respondent has no objection to the condonation of delay of 4 days in filing the connected appeal. Stop. In view of the above, this in view of the above, the delay of 4 days in filing the connected appeal is hereby condoned. Stop. With the above, this IA stands disposed of. Stop. In the mail. Mail, huh? RFSs. This has already been registered, so we can issue notice.
Yes.
Okay. Para, huh? Heard Mr. Same, huh? Both the parties. Para, this is an appeal under section 96, read with order 41, rule 1 of the Code of Civil Procedure 1908. Stop, huh? No. Again, just a minute. The same thing. Just a minute. Huh? By filing the, this is an appeal. Huh? Okay, after that, against the impugned judgment and order, that is 16/5/2023, passed by the Line Civil Judge Senior Division, UPA, in title suit number 36/2017, whereby the plaintiff petitioner, plaintiff is the petitioner here.
Yes.
Plaintiff, the appellant, plaintiff, appellant has been directed. Plaintiff is the appellant.
Yes.
Okay, has been directed to pay an amount of rupees 20 lakhs, 20,40,750. 20 lakhs 40,750 rupees to the defendant respondent. Is principal loan amount with accrued interest for 10 years and 6 months. Stop. Huh? Issue, sorry, the appeal is admitted. Since Mr. Osik, then the appeal is admitted. And then, okay, issue notice. Since Mr. Osik appeared on behalf of the sole respondent, you are appearing on behalf of the sole respondent.
Yes.
Sole respondent. No formal notice need be issued to the respondent. This is okay. Here also you like a plaint, you have made as a defendant. Okay. Respondent stroke defendant. You have received the copy?
Yes, Your Lordship, I have received the
Okay. So then above will be the call for record. Huh? Call for the trial court record. Okay. Returnable, issue notice returnable by 4. Huh? That will be after call for record. And thereafter this. Huh? And then list is matter after 4 weeks.
It's matter 4 weeks.
Lordship, further operation of the impugned judgment may be stayed. The operation of the judgment may be stayed in interim period.
Where have you filed application?
My lord, I've stated in this prayer portion. I've
I
stated
think
in
you
prayer
have to
portion.
file separate.
Yes.
And in that case, you may have to deposit also. Separate, file separate, will pass order. You may have to deposit amount. Because in view of the appeal being admitted, there will be stayed only, but then you should be ready. You file application. Yes.
Obliged.
24.
My lord, here respondent 1, 2, 3, and 5 have filed their affidavits. So this matter may be fixed for admission here as Deputy Commissioner. Affidavit may not require.
Okay. Add Mr. G. Tarak, Land Counsel for the petitioner. Stop. I've also heard Mr.
Standing condition education.
Okay. You are for?
4 Your Lordship.
4
years.
4.
Yes, Your Lordship.
Okay. And you are for?
Respondent 1, 2, 3.
Okay. Mr. Sorry, you are Mr.
Rup Dishitara.
Have you filed Wakalat Nama? Have you filed?
On behalf of,
On behalf of,
sending person.
his name, appearing on behalf of Mr. T. Togam.
Yes.
Learning Council for the respondent number 4, 1, 2,
3 and 5.
1,
2, 3 and 5.
2, 3, and 5. And Mr. Snap. His name have you written? Okay, for respondent number 4. No?
Yes, Your Lordship.
Okay, so as prayed for by the Learning Council for the party, please this matter for admission hearing. Huh? Is it?
2 weeks. After 3 weeks.
After 3 weeks for admission hearing.
Okay.
No obligation, Your Lordship.
Yes, Mr. Ozi.
This is the criminal petition, my lord, and for it is my lord.
Yes.
It is a joint application, my lord, by the informant as well as both of the accused persons.
You are for
I am for all the parties, my lord. It's a joint petition, my lord.
petitioner?
Yes, my lord. They have compromised, my lord. There was a misunderstanding between the parties, my lord.
Okay.
So when FIR was registered, my lord, and
Can copy was called for?
yes, I think
Not available. What is the offense involved?
my lord.
Offense
Offense, my lord,
447,
448, 506 and 34.
The
However,
case
my
is
lord,
pending before
before
which
the
court?
CGM, my lord.
CJM UPR.
Yes, my lord. However, my lord, when the charge was framed, my lord.
Charge already framed.
Yes, my lord. Charge was
Evidence
framed-
recorded.
Charge was framed under section 482, 452 and 506, my lord. 447 was
and
dropped.
50. Have you stated?
Yes,
something?
yes, my lord. My lord, may kindly turn to page 55, my lord.
Page
55. Order dated 29/2023, my lord.
yes. Okay, the allegation is just a minute, huh? Yes. Mr. Athe.
And if my lord turns to, my lord, page 58, my lord. 58 is the settlement deed, my lord. Page 58. First party is the informant complainant. And second parties are the accused number 1 and 2. In fact, they are relatives, my lord. And at that point of time, they didn't know that they were relatives. There was just a misunderstanding between the parties, my lord, and FIR was lodged. And of course, FIR was also lodged. Now they have amicably settled the misunderstanding out of the court. my
So
lord.
there are 2 accused.
Yes, my lord.
Yes,
So
section.
this is joint petition filed by
The informant, complainant, and both the.
who is petitioner number 1 is
Yes, one is the informant.
1 is informant.
Yes,
2 is
2 and
accused number 1.
yes,
2.
2 is accused number 1 and 3 is accused number 3.
What is the maximum minimum punishment? Is there any?
Yes, punishment for 452 is 7 years, Your Lordship.
For 7 years?
Yes,
Is there any minimum prescribed?
minimum not prescribed, Your Lordship.
It may go up to 7 years.
Yes, Your Lordship. Minimum prescribed is 7, then it will be treated as a heinous offense.
Minimum?
No.
Minimum is 7.
No, it's extend to 7. Minimum is not prescribed. Your
Not
Lordship.
prescribed.
The
Okay, then,
offense under 452 is house trespass, alter preparation for hurt, assault, or wrongful restraint,
Okay.
and imprisonment for either decision for a term which may extend to 7 years. Minimum not prescribed.
Okay.
And the
then
second one is
447
506 2, part 2, Your Lordship.
Hmm?
And second, the other section is 506, punishment for criminal intimidation.
50.
That is also up to
No,
2 years.
the chart found in gradient section 452 and 506.
Yes, Your Lordship.
506 is punishment.
2 years, Your Lordship.
Okay,
If, your lordship, in two parts are there, here the charge is under 506 part 2.
Yes.
okay, 447 and 448 dropped.
It was dropped, my lord. In fact, my lord,
323 also
yes, my lord,
dropped.
dropped.
Okay.
My lord,
So-
here, in fact, my lord, here, the informant, my lord, he had a shop, my lord. And during the night time, my lord, this, the accused number 1, he came to his shop and asked for wine, alcohol from his shop. He said that there is no alcohol. So there was a little bit of altercation between the informant and the accused person. And after an hour and so, the accused person, along with the accused number 2, again came back. And then they entered and they honked the horn of the vehicle. And when he came out, and there was a little bit of altercation between the parties. So this is therefore,
what-
pursuant
Mr.
to the FIR was filed.
What is your submission?
Your lordship, since they have settled the matter, an offense of prescribed doesn't fall under the category of heinous offense.
Yes.
So they have stated in their settlement that they are close family relative.
Hmm.
So to maintain the cordial relationship, your lordship, it would be better if your lordship may intervene the matter and quash the same, your lordship. I don't have any objection, your
Okay.
lordship, considering.
Mr. Opada, learned
lord.
counsel for the petitioner. Okay. I've also heard Mr. T. learned additional PP for the state respondent staff. Okay, I'll
There are
pass.
12, 13, and 14 will be relevant. There are 12, 13, and 14.
12,
13 and 14.
13 and
14.
14. Okay, I'll pass with that.
Yes,
My
yes.
lord.
Okay.
Deeply obliged.
Obliged.
This also, huh? Hmm. Just this was item 20.
May I please, your lordship?
ये item कितना था? 25 ना? Just a minute, huh? Yes, this is 26.
Yes, lordship.
Yes.
Please. Lordship, as per this honorable court order dated 28/2024, there are some unclear and illegible documents enclosed in the petition, main petition, very petition, lordship. And there this honorable court directed me to file an IA. So I'm filed this application which is prior to allow me the same, and accordingly list the matter.
IA is for what?
IA for replace of documents.
Hmm? What is this matter about? This is bail.
Yes. There are some page number 59, page number 67, page number 113 to 118, 15. There was some unclear.
We have replaced.
Yes, lordship.
Okay.
Fair to replace the same, lordship.
So document is here in the,
No.
not here. This is for what?
This is for only permission to allow me to file the replace the documents.
You have already replaced.
No, lordship. Till
Not
now.
yet.
After allowing this petition, I will replace the
Okay.
same.
Mr.
G. Fokon.
Learned counsel for the applicant. By filing this IA, Mr. Fukon prays for allowing him to replace the unclear. Seek for permission, huh? Seek permission to replace the unclear and illegible documents. What are those documents?
Documents in page number 59, page number.
Document including annexure. Annexure? Have you mentioned the
Annexure, lordship. Yes, lordship.
These documents are annexures.
Yeah, annexures, lordship. All are annexures.
Documents, huh? Unclear another documents at page 59, 67, 113 to 115, 140 to 160, 178 to 180, 190 to 198, and sorry, 180, 190 and 198 to 200. These all are typed copy.
Some are type copies, some are original, law, I
Okay,
have
the-
collection certificate
In,
copy.
in the
collected.
bail application, in the bail application number, what is the bail application number?
66,
66
2024.
AP 2024. The prayer is allowed. The prayer is allowed, huh? The registry shall do the needful. Okay.
List the matter for motion.
Stop, huh? Do the
Monday.
needful, okay. Para. Then you replace first.
Okay,
After replacement, it will be, okay, register shall do the needful and list the matter, list the BA 66 AP 2024 for motion after done with. Okay.
Published.
Yes, Mr. Lamp, it will be difficult.
Yes, ma'am, it's already
Yeah.
4:45 minutes. Some other days, ma'am. It's appeal, ma'am. First appeal is all there.
You have received the copy of the paper book.
Yes, yes, we have all this.
Okay. Mr. H. Lampu, Land Council for the appellant. And you are for? Respondents. And Mr. T. Mijo, Land Council for the respondent number? Okay, respondents have received the paper book. A copy each of the paper books. So this will be listed for, this is in hearing only.
Yes, supplementary hearing.
You have received earlier?
Yes, we have
Paper
received.
book.
Yes.
Okay, that has already been recorded. That this is that thereafter only this has been
Yes,
listed
yes.
for hearing.
Yes,
Then no need to record that.
no need.
Okay, then leave that. Record their present. Land Council, Mr. Islam Land Council for the appellant and Mr. Tirini, Land Council for the respondents are present. Stop. Due to paucity of time, the matter could not be taken up today. Stop. List this matter next week.
After 2 weeks.
After 2 weeks. As prayed for by the Land Council for the parties. List this matter after 2 weeks. Okay. All right.
Your Lordship, I am amicus curiae in item number 29, Your Honor.
'28 and '29 perhaps is arising out of same incident and same FIR, Your Lordship.
Okay.
So both the matter has been listed together and both the amicus, respective amicus is there. One is for Nani Anju and one is for my learned colleague, Your Lordship.
Okay.
So today perhaps it's not possible to take up this matter. It may be posted after
Okay.
2 weeks.
This all being up Land amicus or legal aid counsel or just amicus?
Amicus.
Amicus.
Amicus for the appellant and Mr. Theatre, additional PP are present. However, due to paucity of time, the matter could not be taken up today. Accordingly, taken up today. Stop. At least this matter after 2 weeks.
2 weeks. Deeply applies, Your Lordship.
Same. And then 30 also similar order.
Same, Your Lordship, but the other side is 2 appeals are there, Your Lordship. Anyways, Your Lordship, same order will work, Your Lordship.
Okay. So
Same
this-
order.
This also due to paucity of time.
Both are tag matter, Your Lordship.
Okay. After 2 weeks. Okay. Yes. I think we are done with.